Good morning, Taylor Gang. Good morning, good morning, good morning. Giving y'all a minute to get y'all life together. The people said that they wanted to stream this morning, that we needed to stream today because we are not streaming tomorrow. And we'll be back after today on, I want to say Thursday. 1 second, let me check something real quick. Okay. I'm here. So yeah, the people said that we needed to stream today. So we're gonna stream today. We're gonna go ahead and finish up day 10, hopefully start day 11. I believe that we are almost at the end of this trial. So it's been moving pretty fast, us being able to move through the breaks. We do miss like a smidget of some of the discussions, but again, I think that we're moving at a good pace, and I do think that we're going to be able to finish by the end of the week. So good morning. Good morning. I see everybody in the chat. Sonya, Jen, Yaya, D Wood, hey Fancy, hey Hershey. You need it, Fancy. Taylor, I went to sleep on y'all last night. Sorry, don't worry about it, Jen. Y'all ready for the new year? I'm ready. I'm ready. Good morning, Beta. Make sure y'all hitting that like button before entering the chat. So if y'all missed out last night, we did vision boards last night. It was fun. It was impromptu. One of my supporters suggested doing it live because I was gonna I made a post about making a board. One of my supporters commented and said you should do it live, and so I just asked a few people, and they were like, "Yeah," and boom, it became a reality. So we ended up putting boards together last night. At least starting our boards. Like my board isn't finished. I'll still be working on it today. There's a few things that I also wanted to print out and add to my board. So I'll be finishing up my board today, but it was a really good time. So if you missed it, you can definitely at least skip to the end of the live last night. It is posted right here on my YouTube page. You can at least skip to the end and watch us present our boards that we created. So thank you everybody that attended, that just watched, and for those who made their own boards. And shout out to my girl TK because she makes bingo cards for the year. Y'all know how we always be like, something happened, like that was not on my bingo card. She make bingo cards. I thought that was so cool. So she sent me the template, and I think I'm gonna make me a bingo card today too. I think I'll make a bingo card today too. I'm thinking my bingo card is gonna be just weird and outrageous things that I think are gonna happen in the world. It's not going to be really about me or things that I want to do. It's going to just be about the craziness that's going to happen in the world. Like a celebrity has a baby, and a celebrity gets engaged, like something like weird and fun like this. So I think I'm gonna do that. So shout out to my girl TK for sending that template over because I'm excited about that. Yeah, so I will just without further ado, I will just jump right on into it and we will get started back up on the trial. And yeah, I'm upstairs today. I'm gonna go back downstairs in a little bit, but I gotta do some stuff up here. So I'll be in the office shortly. Let me get my camera off.
Thought the shooters were. Excuse me, what you say? So, did the state tell you who they thought the shooters were?
The state advised me of who the defendants were.
Okay. And they asked you what? What was the analysis they asked you to conduct with respect to the two people they had already identified?
To determine if it was a drive-by shooting or not.
That was the only purpose?
Yes.
Okay. And you asked the state to go and get you the heights of the two defendants that they had already identified, right?
Yes.
And they obliged?
Yes.
Okay. And did you take the measurements yourself?
Yes.
You have your report there?
Yes, sir.
I want you to refresh your recollection. Okay. You determined. Give me a second. After you did you took measurements of Cortland Henry and of Melly, Jamel Devin, right?
Yes.
And you reduced them, you memorialized them in your report, right?
Yes.
And you determined that Cortland Henry's height was 70.5 inches.
Correct.
Which would be how much in feet and inches?
5 feet 10 and a half.
5 feet 8 and a half.
So 60 inches is 5 feet. So 10 inches after that. 5, 10 and a half.
5 and a half? Okay.
Am I wrong?
I don't know if that's fine. 70 inches. Let's just leave it at that.
70.5, yeah.
And you determined that his shooting height was 60 inches.
Correct.
How did you determine that?
So that was from him standing in a standing position, his arm extended out at 90 degrees. And a measurement was obtained from the ground to his finger.
Okay. Could you stand up, if you don't mind, Your Honor, and demonstrate what you determined was a shooting height?
Yes.
Okay. So stay there for a second. When you say shooting height, stay aside. You mean hand out at 90 degrees? Okay. So when you are determining, stay up there. Right. So when you say 90 degrees, you are assuming that that person was not shooting at that trajectory or that, correct?
No, not correct.
Okay. But your analysis only took that angle into account.
No.
For the standing shooting height.
So you have two different heights. Sorry, two different heights that are made into account. So the one that we just talked about, and then we have squatting with the hand out at 90. So now we have what you just asked for, that window. Follow?
Okay. So you determined a standing shooting height of 60 inches, and you determined that by measuring the tip of Cortland Henry's arm from the ground with his arm extended at 90 degrees from his body.
Yes.
Okay, you said that. And then you also determined you called it a squatting shooting height of 28 inches, right?
I keep tripping with this.
Off the wires. I'm sorry, that's what we can.
Remember that, Jeff?
Anger. Just don't trip. Okay. And you also determined what you refer to as a squatting shooting height of 28 inches, right?
Yes.
And when you say squatting, I think the demonstration you made was doing so.
Yeah.
Right?
Yeah.
Okay.
You know?
And you determined that to be 28 inches.
Yes.
Okay. Now, for Jamel Demons, you determined him to be 4.5 inches shorter.
66 inches.
His standing shooting height was,
57 inches.
and his squatting shooting height was,
31 inches.
so even though he was 4 inches shorter, his squatting shooting height was 3 inches higher than the taller person, Cortland Henry.
Yes, so torsos, you can have a longer torso than Henry. So you can have longer legs but a shorter torso, or a longer torso but shorter legs. So that's how that works to be that way.
So essentially what you're saying is that Cortland Henry has so much more of a deeper squat or a shorter torso that when he squats and extends his arm at 90 degrees, it is 3 inches lower than someone who is 4 inches shorter than him.
Correct.
Okay.
Does that make sense?
That's what you say, right? Okay.
Yes.
All right. Now, what did you use these measurements what did you use them for? How did you use them in your analysis?
So these measurements were used to determine a minimum and a maximum shooting distance from the vehicle.
Okay. I want you to tell me, and you were talking about the perforations that were on the outside of the vehicle.
And to the and yeah, anything from the outside of the vehicle, nothing on the inside.
Okay. So I want to use this red pointer. And let's say, for example, you had an angle like so, right?
Okay.
Into the side of the vehicle. How would you use somebody's height to determine where they were.
Question, Your Honor, outside the scope of direct.
Okay, tell me how.
So you could take, it's going to refer to that worksheet that I showed you earlier. Mr. Howard, are you ready?
I am.
I'm going to try to do this as painless as possible.
Thank you.
So in order to get minimum, and just stick with me here, in order to obtain minimum and maximum distance for a shooter, when you have a known height, I would take, let's say for instance, the minimum height. I would take the minimum height minus the strike mark height, times that by the tangent of the angle, times pi, divided by 180. Now, that being said, say I don't have a distance, or I'm sorry, a height for the shooter. And when you don't have a height for the shooter, you would somewhat reverse these numbers. I'm just going to say somewhat, just to make it easier to understand. You would somewhat reverse these numbers to where you would obtain a minimum and maximum height for a shooter. So,
But you'd have to know where the shooter was standing.
no.
Okay.
So once you have your strike mark, your entry, right? And I put the rod in there, and I get a height of the rod, I get a height of the strike mark, I get a length of the rod, and I get an angle, right? So from there, I would be able to work backwards to determine a minimum and maximum height for a shooter.
Okay.
And that I recently did with an outside agency from the sheriff's office, where they brought a car to me and wanted to know what the possible heights of the shooter are. I can only give a minimum and a maximum. And I gave them a minimum and maximum height of, and just stick with my answer here, of between 5.47 feet tall and 5.95 feet tall. And I said, hold on, can I just finish? And I said to them that it looks to me that the shooter was directly in front of this car, right at the very bumper when he fired into, or she fired into this windshield. The detective then showed me the video, and it's exactly what happened. The shooter was directly in front of the car. So that tells me that my math was correct, and giving them and determining his distance, and then determining a height. So you have to inverse the trig in order to get the answer to your question. And that, we could be here all day doing all that math.
Let me get back to my question in this case.
Right, I thought I answered.
Okay, because in that other case, they had a video showing where the person was and how tall they were, but they called you in to tell them how tall they were in the video, right?
But I didn't know that they had that video.
Okay, all right. In this case, you talk about the length of the rod
Correct,
as being part of the concept, part of the things you know.
yes,
The length of the rod is meaningless unless the length of the rod is supposed to represent the distance from which the person is standing.
No.
Okay, so what you're telling me is that in your trigonometry, if this rod were half distance and not as long as it were, as it is, you would get a totally different number with that same trajectory. Is that what you're saying?
with that same trajectory, can I put it in my formula here again?
I want you to answer my question.
I can't do it without doing the math. I don't know your answer right off the top of my head. That's an unfair question.
Well, let me ask you a different way. You said one of the things that you know is the angle of
Mhm.
insertion or the trajectory into the car and the length of the rod.
Correct.
And I'm asking you that if you do your analysis with a rod that is half that length, will it change your analysis at all?
The length of the rod, keep in mind, the length of the rod is based on the terminal end of the projectile.
That's one end. The length of the rod
So
is
what's sticking out from the hole, from the entry, that's what gets measured. Not the whole rod. So the whole rod going in to terminal, what's sticking out of our hole, if you will, that's the measurement when I say length of the rod.
okay. And the only significance of the length of the rod that is protruding from the hole, the only significance is if the end of that rod is supposed to tell you where the person is, because otherwise the length of the part protruding does nothing other than to indicate the trajectory to you.
The length of the rod has nothing to do with where the person is.
Okay, fine. So if you have nothing but an angle, you don't have the person's height, and you don't have the distance away from which that person was, you're telling this jury that you can determine the height of the person with nothing more than a trajectory rod, and it's based on the length of the rod.
It's based on more than that.
But you do not have the variables of where they're standing, and you do not have the height of the shooter.
I can get the height of the shooter.
Okay. One of the things that you would do in your analysis if you were on this case in the exception is take measurements of the actual shell casings on the scene, right?
100%.
And you would do that in order to try and triangulate where that person may have been standing.
Correct. So the firearm is obviously going to eject, most of them eject to the right. So they'll eject to the right. It's a spontaneous distance. However, it's something of significance that would want to be documented.
Because it gives you some idea of where the person may have been standing.
It gives you an idea of, yeah, I agree with that.
Okay. And in this case, the Miramar Police Department did not take any of those measurements.
Correct.
Okay. And that handicapped your investigation, at least in some manner.
It didn't necessarily handicap it, but it could have made it for a more, it could have made it more, or just brought it more together if the measurements were there. So if I bring the car out there like I did, and I have measurements of where these shell casings are, and then I have measurements of where my shooters are, and then I can I can make a diagram of where my shooter is, where the casing is, where the shooter is, where the casing is. That would make for a more precise report.
Okay.
Which, we measure everything. We measure all of our casings at the sheriff's office.
Okay. Now, in doing your analysis in this case, and we're talking about analysis concerning who may have shot into the car, the universe of people that you were considering were the two defendants that the state identified for you, correct?
Correct.
Okay. So if anybody else on the planet shot into that car, that wouldn't be a consideration that you made in your analysis, correct?
The shooters that were presented to me is what I'm here to testify about. I can't speak for anybody else.
Okay. So your analysis is limited to an analysis of the two people who the state identified for you.
Correct.
Okay. And in doing that analysis, you at first determined that it was more likely that Mr. Demons shot into the car than Cortland Henry. Right?
Correct.
And then we took your deposition. Right?
Right. And then I realized that I used his actual height for the back of the vehicle.
Okay. And then you revised your report and you then concluded that it could have been either one of them.
It could have been both for the entire event on the outside of the car.
Okay. Do you think that the fact that you only came up with Mr. Demons initially was influenced by the fact that that's what the state was telling you?
No. I think that it was influenced by the fact that, as you stated earlier, with your demonstrative there with the rod, when I used his actual height, it made him taller.
Okay. So essentially, you had made a mistake because you used the wrong number, right?
Because for the back of the car, I used his height.
Okay. And when you revised it, you determined that it could very well have been Cortland Henry that shot into the side of that car.
It could be both, actually. So it brought Mr. Demon's height to where it should have been for the back of the car. For the back of the car and the side of the car, it could have been both of them.
Okay. Now, when you did your assessment of this vehicle, you said you were wearing these smart suits, right?
That's all.
And it was so as not to contaminate the scene,
To contaminate the car, yes.
the crime scene, and the crime scene in this case was the car,
Correct.
the interior of the vehicle.
Yes.
And you discovered two projectiles that have been sitting there for 3+ years and had not been discovered.
Correct.
And you also determined that there was blood splatter on the headliner that had not previously been detected.
Blood spatter.
What is it?
Splatter.
Spat. Okay. Thanks. Right?
Yes.
Okay. And you know that that car had been searched at least 3 times before.
I had no idea how many times it's been searched.
Okay. And do you know if they were wearing smart suits when they were rummaging through the car?
I have no idea. I wasn't there.
Now, the blood on Cortland, the blood on that yellow, what was it, a jacket?
I don't know quite what that was.
I want to show you.
Rain curve or something.
I want to show you what has been marked as State's Exhibit 31. Matter of fact, let me put it.
Can I look at them first, though, sir? Sure. It's just distorted something.
That's
Just
just
want to talk about these.
Yeah, just-
Let me get your paper.
While I go up there with that, you're gonna read that. Can we take a break?
Sorry, immediately.
Please.
All right, we'll be in recess. Ladies and gentlemen, just you know, page on the chairs. Remember the admonition to not discuss the case. Don't form any opinion about the case. Allow anyone to discuss the case. What's the next? Told the jury to let it go at 5 o'clock. All right.
I think we should go home.
4:48. I think you should tell them the temperature.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the witness of the defendant. Then to the counsel, the assistant state attorney, ladies and gentlemen, jury, our witness remains on the stand. Counsel, please continue with your cross-examination of the sergeant.
Thank you. Sergeant,
want you to look at this exhibit. Now it no longer has a number on the back. What is it?
31.
31. States Exhibit 31 is this yellow jacket. It's a composite exhibit, so it has multiple photographs. And it concerns, at least part of it, the yellow jacket. See that?
The yellow jacket?
Yes.
Yes.
And here is a closer view. Okay. What I want you to do first is tell me whether or not this, you can determine if that is a knit fabric or it is the fabric consistent with outerwear such as a jacket. Can you determine that from your view?
I think I might need the photo back again. I'm
Okay.
sorry. Do you want me to come to you?
Are you done? What'd you say?
Yes, it looks like some type of knit fabric, but almost similar to a curtain.
A curtain?
Like very not like silk, but somewhere like a thicker fabric.
Okay, like some kind of a little, well, let me take a, I'm not sure if polymer is the right word,
But that's a plastic.
yes.
You think it's plastic?
Okay, this is an outer raincoat.
Is it in evidence?
I suggest using USB, it's gonna be a lot better quality.
Okay, I'm being offered some assistance. And we're going to check. Thank you.
Oh, that's much better.
Oh, thanks. Thank you. See that?
Yes, so yeah, this picture is much better. This is some type of rubbery type surface.
Right. Okay. And because it's this rubbery outer garment kind of raincoat, so you could tell that this was some kind of a smear.
Correct. So blood dries from the outside in, and in my opinion, can you keep still 1 second there?
Yeah, I'm trying to get the full view for you.
So this is, to me, as I testified to another item, and I don't recall if it was this one, but so this is, it was to the seat. So this is what's called transfer, which is a blood-bearing object touching a non-blood-bearing object.
And in this case, the non-blood-bearing object would be the jacket.
Correct.
Okay.
So the blood-bearing object resembles, let me make sure I'm still in drawing, yep, a finger.
Okay.
And also another finger, specifically, and I'm going to put it in a different color so that it can be noted, specifically for that second one that I identified, specifically right here. That would be the curve of that finger coming in, joints, joint. It looks like a finger. So it's a blood-bearing object being a hand touching a non-blood-bearing object. And the blood-bearing object had enough blood on it that it caused it to actually spill over, if you will. So all of this spilt over when it was laid down or whatever. And then, as I said earlier, blood dries from the outside in. And since it was dry, the outside was molested, and it was molested down here. And then that transfer ended up coming over to here as well. So it was touched at least 2 times by a subject with blood on their hands.
Okay. I'm going to take your word for all of that.
Thank you.
But what we're looking at there, you're saying you see 2 fingerprints there?
Can I hold it still?
Yeah.
Okay, so I got my fancy drawer here.
Wait, before I go there, check that.
Okay, hold on.
You see the ridges within that blood mark right up top there.
So the ridges that you see are actually the ridges of the item itself.
Okay, so I just want to make sure. So these ridges are the coat and not a fingerprint, right?
Correct.
Okay, but you're saying, notwithstanding the absence of ridges consistent with a fingerprint, you have identified by shape that whatever bloody surface transferred the blood onto this item were at least 2 fingers.
Right, so can you zoom it back out?
Sure.
And
Okay.
let's get the whole thing, bring it up a little, maybe center it. There we go.
All right.
And so what I'm saying is it resembles, it's consistent with a finger. So again, you have a finger. Whoa, how did I get so big? What did I do wrong? I got it. Never mind. Okay. So you have a finger here, and you have the knuckle and a knuckle of your hand, and then you have the other finger here, right here, which these resemble fingers, knuckle, knuckle. And then again, as I stated, that blood dries from the outside in. This blood over here was all not dried yet, and then you have some molestation of this blood by an unknown object to me, and that originates actually at that crest where it's an empty spot, and it comes down this way. So, but as I stated earlier, there is enough blood on this suspected hand that when this, we'll call it a raincoat, was laid down in the back of this Jeep, that it allowed for pulling to extend out, and that's a substantial amount of blood for that raincoat.
Okay. All right. So the question that I wanted to ask you is whether or not you had an opportunity. I guess I need to say this. Let me get thumbnails on this thing. Let me get thumbnails.
They're charging you for this assistance.
Oh, okay.
Big one.
Thank you so much. Now, this was Cortland Henry's shirt from which blood was retrieved, right?
Okay.
And as distinguished from the jacket, which had a material that allowed you to determine that it was a transfer smear, on a fabric that's a knit like this, you can't tell whether the blood on that is from some sort of transfer, right?
So if the shirt, first of all, it's inside out, so I can't really make a determination on it as it is. However, if you have this shirt where suspected blood is, and you spray our fancy blue star on it, the blue star will show spatter or smearing or transfer.
Makes sense. So that if the hand that might have touched that jacket, they're like that, it will appear as spatter.
So the hand that touched the jacket just like flicked it, is what you're saying?
Well, if in some way the hand was moving quickly and blood came off the hand onto the shirt, it would appear as spatter.
It would appear as cast off.
Okay, which is different from spatter.
It's all part of bloodstained pattern, but it would appear as cast off.
My question to you is the blood that was retrieved, that was found on Cortland Henry's shirt, you don't know how it got there.
I posited that the blood from the front of his shirt is from Anthony Williams' blowback, and the blood on the back of his shirt is from Christopher Thomas's two rounds that he took. Do we have a picture of this shirt the other way around as it would be worn?
I don't know. I know you posited that it was blowback, and just to be clear, your scenario was him sitting still with a .40 caliber being shot from behind his neck, and he does not move, and it came back onto him and splat, right?
Well, I don't blame him for moving. I mean, we have a firearm going off. I don't think I would move either.
Okay. Okay. All right. Then it's not this. Where is it's a white t-shirt? Okay. Okay.
Help with the pictures?
I think these are ready.
Okay.
Okay. Thank you. All right.
Is there any way to rotate it, Mr. Howard? So rotate it to
Not
position.
Yeah.
Perfect. And then
You're saying that it's not possible that could have.
can you wait that?
Didn't do that.
It's sensitive.
You're saying that it's not possible that the blood on that shirt got there any other way than a blowback.
That is not cast off at all.
That is blood spatter from somebody being shot. That's the only possible way that
And
could
it's
have
actually relatively consistent with the blowback that's on the headliner as well.
happened. Okay, so I'm just understanding that your opinion is that there's no way that that blood got onto that shirt other than blowback from a gunshot.
Correct.
And your reasoning is?
Well, he was wearing the shirt. He was seated in that position. A gun strikes Mr. Williams. The blowback goes into the air and lands on him, lands on the headliner, lands on the back seat.
So all of the reason why you're saying that it's impossible that it got there any other way is because you're assuming that he was sitting in the seat, in the driver's seat at the time the shot was fired.
Well, I'm not assuming because it's clear in the pictures that there is no blood on that seat. And the explanation for that is because somebody is in that seat.
And it's Cortland Henry, you know that for sure.
If whoever is driving the car,
So the car was moving at the time these shots were being taken?
whoever was driving, whoever was seated in that seat.
Whoever was seated in that seat.
Correct.
Okay.
But that's cast off. Can I look at the back one?
Okay. That's actually the front.
That's his watch. This is the t-shirt he's asking to see.
You want to see the back.
That's the back.
Okay.
The back is a large logo.
It's the back.
Yeah, that's not going to be,
I didn't do that.
I think you did. That's not transfer either.
Okay, that's definitely coming from blowback.
Yes.
Okay. And your the reason that you are saying that is?
It's shape, it's consistent with, and it's coming down. It's coming from a up and down onto the shirt, and it can try not to touch it.
I'm not.
So, all right, I'll use white. So this is actually white. So this is actually coming down, and this is coming down also. So this is coming from above. I'm sorry, I'm losing the microphone. This is blood coming from above the shirt. So that's not going to be transfer.
Okay.
So this is blood that's in the air and coming down onto the shirt. And that's what I'm reading in these photographs for the back of the shirt.
Okay, you done with that?
Yes, sir.
And the only way that blood can come from up down onto a shirt is if it's coming out of a wound when a bullet hits the person.
Correct. So it's going to be coming, and it's not necessarily that it's going to be, it's, if you shoot somebody in the arm, it's not necessarily going to cause as much blowback as the head. So the head is the one that's creating the majority of this blowback.
That would be the time.
All right, ladies and gentlemen, we're going to pick it up tomorrow, so remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case with presence, and certainly no research. Just leave your notes head on your chairs, we'll see you right back tomorrow. Thank you, ladies and gentlemen, have a good night.
Judge, if I can leave my stuff here.
Just 1 second. Let the record reflect that now Councilman Melly is finished. And is this the attorney, anything to discuss, guys?
Just one thing, Your Honor. Today, this afternoon, the Defense Counsel filed a notice of deposition for this Friday without consulting with myself. I submitted all of our availability. I am not available for a deposition on Friday. I have other meetings and things that the time is selected. So I was going to ask if Your Honor would be so kind as to intervene and perhaps tomorrow, have it set for tomorrow afternoon. And to go over that on the deadline tomorrow afternoon, I think we will finish with Sergeant Williams, and then there's one of the records custodian for the morning that's a quick witness, and then we could do this afternoon to take the deposition.
What are you going to produce? Is that wrong in it?
Are you going to produce it?
I have been trying to serve the witness, he has failed to do. So,
The only reason I did that, Your Honor, and it's my fault, is he just recently got a new address on this witness. It is Trevor on Glass. That was one of the witnesses that I had filed a motion for better address. I got a better address and tried to serve him at various addresses. I filed numerous motions to exclude him. Judge Siegel would not grant that and basically said if the state produces them, we'll recess and take his deposition. As soon as I got that new address, they want to produce them tomorrow afternoon.
So you don't have a, you know. you don't-
Oh, yes, we do. We did. We served
He
a
was served
person at that
last
house.
night. His mother was served at 5 o'clock last night.
So we scheduled it for Friday because, we're off on that day. And we need time to transcribe that witness if the state is going to call him as a witness, and we didn't want any delay. If they want to produce them tomorrow and the court wants to recess early, I'll do whatever they want.
So then my concern is that defense counsel said this unilaterally, and I've been here next to the court for the last 2 days. They obviously went about for taking steps to do this, not just like serve, but took no steps to coordinate this. They have to do that. I cannot do this witness. I cannot have service on him to get him to show up for a deposition on that. So I would just ask Your Honor.
Can I stop you for a second? Do you have service on for the trial?
We made several attempts, and in fact, Your Honor, I spoke with him myself. He indicated to me that he was not coming, and I asked him if I could arrange transportation, arrange a hotel. He said if I sent a plane for him, he would not show up. Those were his comments.
Well, and so then to follow up as to the next statement that he made to Ms. Smith, would you be kind?
Yes, Your Honor, he did in fact tell me that he felt concerned for his safety, that the state requesting him to be here in Broward County was a risk to his life, and that the state had no concern for his safety, and he refuses to come here out of fear.
So.
He refused to say who, Judge. I did ask him if he was threatened or requested not to appear by anyone, not insinuating from any specific person. He said, "What do you think?" And I said, "I can't speculate," and he refused to further comment.
So you have service on.
We have a subpoena served, I think, on his mother, accepted service for Friday at 10:30.
And I'm waiting for the affidavit or I will file it.
And, yes, ma'am?
I know that, and for Judge Siegel on a hearing on a different case on Friday morning.
What case?
Calvin Smith, that is a 2007 triple homicide, that he has been in the hospital. It's with regards to his placement, and if he's hit his mark for 5 years for continued incompetence or would remain.
And how long is your hearing? Was this?
It is scheduled for an hour from, let me double check on this, am I scheduled? It's scheduled from 11 to 12 on that. They set the deposition without any notice of attempt to coordinate with myself for 10:30.
Understood, and I understand they're supposed to try to coordinate with it, but regardless of that, because the circumstances in this case, or you suggest, it's all speculation, but if Ms. Smith indicated that he indicated he wasn't going to cooperate in any way, shape, or form, the chances of him showing up for this deposition are slim and none.
Agreed. My concern though is that this is the second deposition we've had the discussion, because then the next thing I have to bring up with Your Honor is we're gonna have to coordinate an additional deposition because defense had deleted a witness from the witness list in March of 2022. And then now they just told me today that they are going to add that witness back on. So I canceled the previously set deposition of this witness, and so now they're putting this on again last minute in terms of that. So we're gonna have to have court intervention as well as to that scheduling and making sure everybody's available for that.
May I respond to that? She provided case law last week, I think last Friday, which now requires us to put that witness back on.
And we agreed to produce him next week.
Whatever she wants.
What
it will
at
be
their
that.
convenience.
Who's the witness?
It would be our cell tower expert or cell phone.
So, you know, pick a date next week and do it. What's the?
Yes,
Coordinate.
She can do whatever day she wants.
So we made attempts to coordinate, and they failed to make attempts to
We'll,
coordinate.
we'll coordinate.
We're just asking for the same courtesy.
No, we will
This
coordinate.
morning, I said, give me a date.
And so,
That's a non-issue. Next week, they've agreed they'll produce this cell tower expert. So let's go back to the witness, I forget his name.
Carry on glass.
So assuming, Ms. Smith, are you available on that date?
Not at certain times, but I also have been scheduling all my
No,
other
I
cases.
understand.
Yeah, I have Judge Fine in the morning, and I have a deposition at the jail at 1 p.m.
All right, so I don't know, how long is this deposition supposed to take if he shows?
It's set for 10:30. I would imagine that we would finish certainly by, well, if he doesn't show, we'll be out the door at 11. If he does show, I anticipate the depot would take somewhere between 1 and 2 hours.
And so, Your Honor, I also have other hearings that morning starting at 8:30. I am before Your Honor on the co-defendant on this case. I have 3 other hearings from Judge Davis, Judge Fine, and Judge Z.
They're not going to work with you on either rescheduling, having somebody stand in, like for Mr. Henry's case. I mean, that's just the status.
No, there's been a motion set filed by defense.
I saw it. It's-
So,
I can reschedule. It's not an issue. We can talk to the defense and your trial and kind of pick a jury. I mean, I'm not pick a jury, but take that position of a witness. That, to me, that takes priority.
of course, Your Honor, I agree, but my just concern is that there's no professional courtesy from defense to the state.
I agree with
So can
you.
we just move it to
agree.
the afternoon? I'm available
They
later
don't
that
have,
afternoon if
they
you
don't
do
have
it at.
service on the witness in the afternoon. They have service on the witness in the morning. Where's the deposition supposed to be taken at?
The Zoom deposition?
Well, we changed it to a state attorney.
At the state attorney?
Yes.
Yeah, he's.
To make it easy.
And this is a witness that is not local and doesn't live here? So is the deposition been served via Zoom or is it via personal service through our neighborhood travel? Because this would be a witness that resides outside of the jurisdictional bounds of Broward County. And as such, we would be required to travel to his location to take the depo for the rules of criminal procedure.
There's a lot of information there. You got service on him through his mother, but it's not his residence?
It is-
Whatever the address they gave us, and they just gave it to us last week, we immediately attempted, and we knew we needed, we figured we would take the depot on Friday so that we would have time to transcribe it and not cause any delay. Because we're under the impression, and Your Honor did not grant the motion to exclude these witnesses that we've attempted to take depots, attempted to serve them in numerous places over the last 2 years. They are listed as A witnesses. I suggest to the court that they are material witnesses if they show. And we're doing everything we can under the circumstances not to delay this trial. I mean, I don't know what else to say.
I understand what you said, I heard it. So this is my thought, I don't know who you have hearings with tomorrow, you mentioned Judge Fine, you mentioned Judge Siegel. I don't know what Judge Fine's schedule is or not, I don't know what Judge Siegel's schedule is or not, but I'm sure that is something that we can work out. I know as to the case you have with me, I'm sure it's something we can work out. So.
Of course, sir. But again, I'm just being told now that I'm supposed to now provide the room.
I agree with you about you should have been noticed. I don't have any issue with that.
I take full responsibility and I apologize.
But the question is, what are we gonna do now?
Well, if it's on Zoom, that's a lot easier, because then I can jump on and go from there. But for defense counsel to then all of a sudden make this here in person without any notice to the state seems highly irregular on that. So this is still gonna be on Zoom, the witness can show up and then be told, we moved it to this afternoon when everybody is available, and do it at 3 p.m. after Ms. Smith and I are available to take this witness's deposition.
So is it on Zoom?
We served them on Zoom for a Zoom, and we changed it because of how material he is.
So it's not on Zoom, it's supposed to be scheduled in person.
Yes, sir.
We'd be fine with striking the witness if the state
I mean,
wants.
exactly, if they say they've talked to him and he's not coming, just remove him from the witness list, for God's sakes. I mean, we've been trying to take his depot for 3 years, Judge.
So we'd be happy to go forward to very much doing, because he feels threatened and can't be here in court.
I,
Just one incident.
All right, so this is the way we're gonna handle it, all right? The guy's noticed to be deposed. Now it's not a Zoom deposition, it's in person, it's inconvenient. It should have been noticed to you, da-da-da. I agree with all that. We're in trial on a serious case, state seeking the death penalty. I mean, sometimes we have to change. They were able to get service on the witness. Let's see if he shows up. So if you need assistance with any of the judges, I'll take care of it. You let me know who it is. I'll either reschedule those hearings. I'll ask my office to do that. And we'll contact the judges, just tell them that you're incapacitated because you're taking a deposition.
Not a problem, and just so I want to make sure that travel has been arranged for this witness, if we're doing it in person.
It's a 2-hour drive, I don't understand why you're being arranged to travel.
Pardon me?
It's a 2-hour drive, I believe, from his house to here.
I don't know any of that. Candidly, I don't typically arrange for travel or have it, but whatever the rules provide for, that's what the rules do.
if there's any travel expense, if he shows, we'll reimburse him.
All right, so let's just see what happens. My guess is if Ms. Smith's conversation is correct, he's not going to be here anyway. So let's just see what happens, all right?
May I suggest that the state attempts to call him tonight or tomorrow and see if he's going to show?
Or strike him.
Why are
Or in the alternative, strike him. I mean, Judge, we've tried like numerous times to get these witnesses.
you here?
I mean, we're in the middle of the trial. I mean,
Yeah, Judge, may I just say that there has been this ongoing problem with respect to these witnesses. This particular witness now, we're being provided an address and simultaneously being represented by the state. He's not going to show. So we should probably stop with the charade regarding this particular witness and just strike it. If they're saying he's not going to be available, I don't know why we'd be jumping through hoops to waste our time. Just strike him from your list and we can all move forward.
Well, there's other remedies available to the court, or the state.
So I'm not gonna go around in circles, all right? So if the witness shows up for deposition, he shows up for deposition, and if he's gonna testify, he'll testify, and we'll see what he says on Friday, is it? All right, so you just make yourself available for that. If you need the court to contact other judges to let them know what's going on, I will.
Thank you, Your Honor.
All right, so just leave it as it is, and when are you gonna let that council know the date you're taking cell tower experts?
And looking in terms of scheduling and whatnot on that, we can do it on,
exactly.
I'm gonna have to do a couple of scheduled juggling on that, because
Hey, Joe, thank you. Please be seated. Let the record, once again, the jury, defendant, defense counsel, attorneys. Ladies and gentlemen, I trust you had a nice night, and we're ready to begin now. The state indicated that they wanted to call a witness out of turn. Detective Sergeant Williams is here, but he's just waiting outside as a short witness the state wanted to put on now out of turn. The defense indicated they had no objection to that. So we're going to call that witness first. Who is the witness?
Sean Newman.
Good morning. Are you Ms. Sean?
Yes.
Welcome.
What I'd like to do is remain standing, raise your right hand, and be sworn.
Do you solemnly swear or affirm the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Tashawn Newman.
Please spell your first and last name for the court reporter.
First name is Tashaun. Last name Newman.
Thank you. Please have a seat. I want the record to, Ms. Newman, there's a microphone in front of you, it's pointing straight up, it should be moving down, all right? Just that way. You all set?
Yes, sir.
Thank you. Counsel, you may proceed.
Thank you, Your Honor. Good morning.
Good morning.
Can you state your name and where you're currently employed?
My name is Tashawn Newman, and I work for the Florida Department of Transportation Turnpike Enterprise.
Okay, and what is your role or your assignment currently?
I am the account research manager. I oversee the department that does extensive research into accounts, as well as we fulfill public records requests.
Okay, and prior to your position as an account research manager, what was your position?
Financial investigator.
And what were your duties as a financial investigator?
A large portion of that position was fulfilling public records for law enforcement, as well as for our legal department.
Okay, and in this particular case, back on or about October of 2018, did you receive a subpoena, not you specifically, but the corporation, received a subpoena regarding video surveillance from October 26th of 2018?
Yes, they do.
And in the form of legal service, correct?
Correct.
Either subpoena or public records?
Yes, ma'am.
And did you fulfill that request?
Yes, I did.
And are video surveillance kept in the normal course of business by your department?
Yes, they are.
And are they essentially made out of near the time of the event, here specifically October 26th of 2018, and routinely kept?
Yes, ma'am.
Your Honor, at this time, I will be showing defense counsel to mark this case on Google kept for identification purposes. May I approach the witness?
Yes.
And Ms. Newman, did you have an opportunity prior to your testimony to review the USB?
Yes, I did.
And what is it?
It's a USB with the various videos of the toll roads on the expressway.
From October 26th of 2018?
Yes, ma'am.
Is it in the same or substantially the same condition as when you last reviewed it?
Yes, it is.
Any alterations or deletions that you can see?
No, ma'am.
Your Honor, at this time, the state reviewed this evidence states quadruple F, that states 81.
Is there any objection?
No, sir.
Thank you. It'll be admitted.
States quadruple F, trademark states 81.
No request to publish at this time, Your Honor. No further questions.
Counsel, is there any cross-examination of this witness?
I have no problem.
Thank you, madam. Thank you very much. You may step down.
Thank you.
You're excused. Who's your next witness? We're back on with Sergeant Williams.
Yes,
We have Sergeant Williams come in.
Yes, sir.
That's his introduction. It'll be a minute, ladies and gentlemen. Very entering. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our defendant, Mr. Demmons, his counsel, the assistant attorneys, ladies and gentlemen of the jury, and our witness,
Christopher Williams, Sergeant Williams remains on stand. Sergeant, I just remind you, you still remain under oath, all right? And I think we're in the middle of your cross-examination.
Yes, I have nothing more for Sergeant Williams. Thank you.
Okay.
Further questions? All right, is there any redirect?
Yes, Your Honor. Good morning, Sergeant. How are you?
Good morning, Ms. Franklin.
So with regards to the autopsy photos and things that you reviewed, how were you able to get the approximate shoulder width of Mr. Thomas?
So the medical examiner's office, they use a scale it's a big ruler that goes the length of the autopsy table where the decedent is lying.
Okay, and in terms of that, so you got that 2 feet 6 inches from approximately?
Approximately.
In terms of, counsel asked you with regards to the multiple times as to how did you rule out that someone was outside the car? Why? Why did you do that?
And that was explained in them also multiple times. It's the blood that was on the headliner, the lack of blood in the passenger side rear seat, and the GSR that was inside the vehicle.
Okay, with regards to ejection pattern testing that counsel asked you about. If you're going to do an ejection pattern, what would you have to do?
You'd have to have the firearm, and you'd have to have the ammunition to conduct that test.
And in terms of the time frame on the casings, is it important to find them immediately after?
It would be very important to find them immediately after.
So a month delay in finding them, could you do ejection pattern testing if it's a month later?
You can, well, if you have the firearm, you can do ejection pattern testing. How it would apply to on the side of the road, you would have to do that on the side of the road with that firearm.
And if individuals have gone back and picked up casings from the scene, how would that affect ejection pattern recreation?
Individuals as in strangers?
For people that were friends with the defendant, if they went back to the side of the road. and-
Objection, Your Honor.
Abstain.
If individuals went and picked up casings, not knowing they were involved.
Objection, there's no evidence.
As that question's over, the objection's over.
So if they were picked up, it could alter it, but at the end of the day, it still needs to be measured.
So in terms of the shots that are in this vehicle, how can you tell the approximate distance that the shots were fired from?
The approximate distance is obviously going, as I said, this is a unique case where our shooting is contained to a vehicle. So we have known distances within the vehicle, we have known distances of the, not necessarily the arm, but we have a known distance of inside of the width of people, and the stippling pattern that is on Christopher Thomas, who's on the back seat, and some of the stippling that is observed on Anthony Williams, who was in the front seat.
What about on the outside of the car? How can you tell that that wasn't shot from a mile away?
You can tell that it wasn't shot from a mile away by the angle of it and its type of impact into the vehicle. So if it's shot from a mile away, the projectile is going to start tumbling again. It's going to go head over heel. As it loses velocity, as it loses its spin, it's going to start wobbling, and then eventually will start going its head over heel and then keyhole into its target.
Did you see any evidence of distant fire in this case?
No.
In terms of the defendant in this case, you said you measured him?
Yes.
Do you recall about what date that occurred on?
Can I repeat?
If you need to refresh your recollection, please do.
November 30th of 2021.
And at the time that you measured him, was it here in the courthouse?
Yes,
And that's where your office was at the time?
yes.
And could you describe his build?
He's slender, but he's tall but slender.
And in terms of, would you say that he has broad shoulders?
No,
And you said he was 5'6", right?
correct.
In terms of that car that we were talked about, what's the best way to get an idea of how big the inside of that car is?
You can measure it, or you can also view it.
And where is that car right now?
That car is in the crime scene unit forensic processing garage right now.
Is it available for the jury to view this morning?
Yes.
Here, if we may approach.
Thank you, sir.
Thank you.
Madam State, who's the next witness?
Judge, you're just requesting a 5-minute recess to set up some videos for the next review.
All right, ladies and gentlemen, take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Don't further no research.
It went through there, blink. Okay, everybody.
Thank you. Let the record reflect the words of the defendant, Mr. Devens, his counsel, the assistant state attorneys, ladies and gentlemen of the jury. Ladies and gentlemen, I think their state's ready to publish. Is that correct, counsel?
Yes, Your Honor.
What exhibit number is this again?
State Publishing states 81.
81 and evidence.
Yes.
Give the license.
For record purposes, I'm going to begin with I-595 eastbound and westbound express 102618 0320 through 431 eastbound lanes.
We're seeing a case here where the prosecution doesn't have all the pieces of the puzzle. They don't have the murder weapon or weapons.
Thank you, let the record reflect the documents remain on the defense. So, the videos, these are things.
Media production, those are been entered into evidence. The extraction would be the next thing the state will be publishing, which would be the 300 photos that we had pulled out to show that it's the defendant's phone.
So, let me see what's on it.
Sure. And I think we already done some of these, but I'll start playing them.
Then I got the same people, and we'll all be speaking on do that, let's do that, let's do that. Then I got the same people.
Thank you. So, these videos are just to show ownership of the phone.
Ownership of the Snapchat account. That was the video we previously edited, Judge.
Come on, all right, extra shit. They need the most important shit here. Right now.
So, stop for a second. Which ones are you saying are, need a balancing 403 analysis?
Well, many of them are either way before this incident or way after. I don't know what the relevancy is.
She's explained to me she's trying to establish who owns the Snapchat account because there's a dispute as to ownership of the account. That's the way I understand it. Is that correct, madam?
Yes, sir.
Could we just see that last video again, for a second?
This one? That's highlighted?
Right now.
I know on these videos before there was an objection, and I took out firearms, and there's also one with
money and cash.
all right. Anything like this on any of these?
Okay.
Do you have anything on any of these?
The next one as well? They both?
This one?
Yes.
This bitch look like he got 5 kids at the student pickup right now. Waiter.
Do we know who Snapchat is based on what we just saw, whether it was the other gentleman or Mr.?
What's the 403 analysis?
Well, the relevancy, the 401 analysis.
Right, I heard 403. All right, so relevance on past because they're trying to establish who owns the account. So the relevance objection's overruled. What's the 403 analysis?
Okay, I understand, Your Honor, that it is overruled, but I'd just like to actually make the argument, which is, if their purpose is to establish ownership because of who is depicted on the videos, that would be undercut if we're seeing other people depicted on the videos. That does, if the person on the video establishes who owns the account, then it might be the other person's account. So that just shows that the argument does not carry weight. As far as the 403 analysis.
You can argue that to the jury. You can argue that to the jury.
Okay, I want to put my relevancy argument on the record for the court to consider. As far as the prejudice is concerned, Your Honor, in each one of these, depicts Mr. Demons in a, what may be, and we've only seen it, one thing we want the court to do is see them all, not assume the balance of them is not going to contain information that may have a 403 objection. So we first want to see them all and not be ambushed and try to unring the bell after.
You haven't seen them?
We haven't seen the ones, we haven't had them identify the ones that they intend to play. I mean, if you download some social media with millions of items of information and then come in here and cherry pick some to show, we need to see what they intend to play so that we can have some basis to either interpose an objection or not.
That's what they call a motion in limine. You file a motion beforehand, say, Judge, we need some determination as to all of these videos, which ones they're using or something along those lines. So we're not sitting in here while the jury's sitting in the jury room saying, what are they doing out there?
The other reason for the rules of evidence and the need for authentication is before they admit it into evidence, at the time, they establish its relevance. So this is the time for that. Not us asking, looking at 16 million items and saying, out of these, we are going to ask you to eliminate 14. The proponent of the evidence is the one that carries the burden of establishing the relevance of the evidence they propose to admit. And at that time, the relevancy or 403 objection becomes ripe because of what is ensued in the trial and what is left to be proved. And that is our position, Your Honor. And it seems that they only have maybe 8 more and they're a second apiece. I'm not quite sure what the prejudice would be to having them go through them so that the court can see what it is.
So it's clear for the record, that is all the videos on Snapchat, that's the entire production that was sent in, so we're not cherry picking in any way, shape, or form on this particular exhibit.
How many are there?
There's 5 more, Judge? 17? And
Could you go back to the one before that for a second?
No, we're just gonna go through it. We're going through all of it. Let's just get it done.
last one. That's it.
Thank you.
So the one that we would have an objection to primarily is the one that they have 3 versions of towards the end with music lyrics in the background saying that "and will kill you." That we think is objection. It's not his voice, it's a song in the background.
Lady. Thank you. What's position state?
That is sent to one of the witnesses, and that it is a threat to them, and also an admission to the incident we have here today. So I'm going to cross-reference just a moment with.
What's the date on it?
11/22/18.
I'm sorry?
11/22/18.
And that was sent to, hold on. So that was sent to 2 different individuals that then are in this response that they're showing on the screen now, Your Honor. that there's a message that was sent from the defendant. It was a reply, that was a post that he had put on November 22nd, 2018. Then through the 3 messages on items 5, 6, and 7 are responses indicating that Mr. Demons had posted that specific message online and acknowledging it that they had seen it as one of his stories at that point.
Your Honor, the state just represented initially that they were putting on this evidence to establish the owner of the phone. We then recognized that to have been a pretext because now the state is claiming that the purpose for those highly prejudicial videos is to show that they were sent to a witness. When asked to prove that, the state is demonstrating that it was posted online and somebody responded to it, which is not what the state said. It doesn't show it's being sent to a witness, and it's not for the purpose of establishing its phone, that it's its phone, and it contains lyrics that are prejudicial, and we object on 4 or 3 grounds.
We should say that.
Judge, you can always play it without the sound if that's what the defense is concerned on, and still shows that it is his.
You're saying, though, the messages reflect that there's a threat?
It does, Your Honor, and I think that is relevant, and based on the time frame of when it was posted after the homicides, that it is something that should go before the jury. But Your Honor, if Your Honor is going to make the balancing call on that with regards to if the audio portion is considered too inflammatory, the video portion can be played without any audio.
So what do you need the Snapchat account for?
So in terms of the information that's already been identified as Melly, Montana, as belonging to the defendant. And if you go on down here. This particular message, which is authored by the defendant, sent to Ms. Hamilton, saying that the individual known as Port, also known as Portland, saved in the phone, which is this co-defendant, Cortland Henry, says that he saved the life of Mr. Demons, and he's coming everywhere with him because if the crackers come grab him, it's my fault.
What's the date?
That is November 9th of 2018. In addition, Your Honor, so here's the entire text of it. Make it easier to read. So in addition, Your Honor, the name, Melly, Montana. In addition, the Melly Montana name links back to the Celebrate, which also helps show and support that the phone in state 64 belongs to the defendant.
Anything else?
With respect to the statement itself coming in, our position would be that there is no contextual reference of what it refers to. These people have known each other for a long time. Outside of that, if that is what they're using as the predicate for needing the Facebook account and evidence, and the court deems it to be relevant, the state has offered to play it without prejudicial audio, and we think that would be an acceptable compromise.
Thank you. Any other Anything else contained in the Snapchat that has, that you're alleging is threats against witnesses? Because I haven't heard anything about a threat to a witness.
No other words.
Pardon me?
No other of those, no.
All right, so regarding what counsel is objecting to, the audio portion of those 3 Snapchats, I agree with. On a 403 analysis, take it out. So how long did these run?
Those would take about 10 minutes, and then the state would be intending to publish the 300 photos that we previously identified and showed.
Showing the counsel 300 photos?
Yes, they were the ones that we previously shown. And so in terms of, to make it clear which ones are published for the record, you can put this in to explain the thumbnails and then identify them as by the image number on that, as opposed to putting the entire file name for each image in.
These are the exceptions from.
State 64. With his cell phone.
These are. And this is for the purpose of establishing.
It's his phone.
These are the ones that we. Okay.
You can look at those. If you want to look at
The actual photos themselves, you have those.
sorry, what you go for. So, for example, see, we have a special codec installed.
Things are those, right?
Yes. Sure. Worked on there, there was 2 that just wasn't clear that that's what it was until the council pointed it out. But as to the money and things like that, those are images that were taken on the phone. Sometimes there's 5, 6, 7, 8 shots of that particular outfit or whatever the issue may be on that, which shows that the individual has all of the photos. It's not just the one that's posted to social media. So it's important to show that there are multiple takes to get the best one that's later posted to the social media websites.
Thanks. What's the objection regarding the money? Shots of the money?
It's not relevant. For the same 403 grounds that the court introduced the subject of money earlier, which is to the extent that it might be off, I'm not quite sure what the court's thinking is, but to the extent that it might be off-putting to see somebody flaunting their means, we think it's unnecessary. Plus, there's an as far as the 403 balance is concerned. If the court, if the state's purpose is to establish the ownership of the phone and they're putting in 300 photos, if we take out 20 photos of marginal relevance and potential prejudice, I think the 403 balance clearly weighs in favor of exclusion. It's cumulative and it's also cumulative and unnecessary. And that what the court has in hand is handed back are the hard copies. The reason why we're taking so much time over there with the state is because there are some digital images that the state was unable to print. And as among those, there are fewer that we seek to exclude, but they would be for the same reason. And the state would have to, at some point, go and take those out of the digital image, which would be removing it's either money or guns. And I think that's it.
And you're saying that the pictures related to the money are important because why?
Showing who's using the phone. There are multiple images of the defendant in terms of they'll be taking 30 and 40 photos on one day, but only one is posted to social media. This is to be able to make an argument later on to the ladies and gentlemen as a jury that this is the person who had that phone, who's using that phone, because there's only one, the best image that's selected that's put on social media.
Also suggesting to me that there in that array of photographs there, that the total photographs with cash is 20 or so approximately, where it's flaunting funds, and more than enough to establish the point that you're trying to establish.
So in addition to that, there's been no testimony that's real money. In terms of that, there is movie and prop money that's referenced in other places in the phone. For example, there are notes in the phone in which the defendant has a wish list of things where he says he needs fake money to do a video shoot on that. So I don't think there's any undue prejudice on that and saying that there's any sort of financial means.
Anything else?
No.
I don't think it's necessary, so sustain the objection.
Okay, so we'll go through and then create a new selection of those photos with defense, and that way we can get that forward to the ladies and gentlemen jury.
And how long is that gonna take?
About 45 minutes.
So I'm gonna bring the jury in now, send them to lunch, tell them to come back at 1:15, like, give you enough time.
Yes, sir.
Before we do that, I'm of the impression, and I might be wrong, and I stand corrected if I can, that this concludes the evidence that the state has to present today, absent the court ruling that the jury can go and view the automobile. And we have been presented with a written motion that they have fashioned very quickly, nice and efficiently. We would want an opportunity to respond. And so we would object to the viewing of the vehicle today. And if they're going to take 45 minutes of the jury's time to take out photos digitally, and that's all they're going to do when we come back and play them, we might as well conclude and pick this thing up on the 10th when we return. So that's just my suggestion, and it's predicated on an understanding of what the state has left to present.
Thank you. So what is it that you need to do to prepare for a motion to do a jury review, Council?
Well, look at some research, particularly with respect to the purpose for that the state has advanced, which is to demonstrate the dimensions of the inside of the cabin of the vehicle. If it is to do that, the jury going and viewing a vehicle with 5-year-old congealed blood in it, a scene, we might very well be able to find a substitute automobile that is clean, that we can rent, that will serve the same purpose. So if the court is of the opinion that the state is entitled to have the jury examine the dimensions of the vehicle, they can do it in a clean vehicle where there's no prejudice. So we want an opportunity to go rent one so they could go and see it, opportunity to find one that is of exact dimensions so there'd be no prejudice, and proceed that way, and an opportunity to research whether or not under the circumstances they'd be entitled to do it at all.
In addition to that, Your Honor, we asked the court to review the Judge Siegel's order denying the state's motion for review by jury of the proposed scene on the grounds that there are numerous photographs. The exact language is, the state has ample evidence from which a jury can gain an understanding, and in this case, the place where the alleged shootings of the vehicle out of 27 occurred. And as such, the court, Judge Siegel, denied that jury. There are plenty of photographs of the Jeep. I think the state introduced somewhere in the area of about 40 to 50, possibly more, photographs of the Jeep. There's no need to do that, but if the court is considering it, we obviously need time to do a little research.
Hearing the state what you just said, asked defense counsel numerous times if they wanted to view the vehicle and be able to make an accurate determination of that. They've declined to do so on any prior occasion. The vehicle is downstairs. If Your Honor and defense wanted to look at it to understand that it is not gory or gruesome in any way at this point. There's no bright red blood stains or anything like that. I would suggest that would be important for defense counsel and Your Honor to see before making any such determination.
Well, a couple things. Number one is that I wasn't aware that Judge Siegel already ruled on a motion for a jury review.
Not of the car. That was done with regard to transport the jurors to the scene, to give them an understanding of the time and space from Fort Lauderdale to the edge of the Everglades. So that was a separate with regards to a jury review in terms of transportation and things like that. So
You're suggesting what Mr. Adelson just represented to me had nothing to do with the jury review of the vehicle?
correct.
That is correct. I said the scene. And if the court misunderstood me, I apologize if I did not.
I didn't hear that. Regardless, Counsel, I spoke with Mr. Tom Wolf, who advised me that you mentioned to him this morning about the jury review. He came to me, and then I got a call from Captain Tianga telling me that it would basically be impossible to do a jury review today, that if they were going to do it, they needed time and wherewithal to a secure area because the jury review would, I assume, require the defendant to be there. They'd have to be unshackled. This counsel would have to be there. You'd be there. I'd be there. The jury would be there. And it would be, they'd have to secure the area. And what was explained to me by Captain Tianga is that's not a secure area downstairs. And he is concerned about it. So he said it couldn't be done today. And if you went so far as to ask for a jury review of the scene from Judge
Siegel, I would have thought you would file a motion pre-trial regarding seeking a jury view of this as well. You didn't, and I would have thought you would figure that out before you say something to the jury that it can be done or would be done. That's the way it was. The implication I got. I would just think you clear that with the court before you start telling the jury about it. In any event, so we're going to bring the jury in. I'm going to tell them to be back at 1:15, and you go ahead with your publishing. But according to what I've been told by BSO, a jury view isn't happening today. So we can talk about the motion. We can set it down for hearing next week or tomorrow, whatever you all want. We'll figure out. Pick a date. We'll talk about it. But it's not going to happen today.
Understand.
All right, bring the jury in, please.
Jury entered.
Ladies and gentlemen, thank you. Please be seated. Let the order once again reflect the votes of the defendant and counsel. These are state attorneys. Ladies and gentlemen, jury. Ladies and gentlemen, I apologize. It's going to be quick. I'm not done with the attorneys. I need some more time with them. So we're going to break for lunch now. See everybody back at 1:15. Just remember, you can't discuss the case, all right? Take no bets on it here. No research. No forming anything about the case. No allowing you to discuss the case. You're correct. See you back at 1:15. Thank you, ladies and gentlemen.
Outside of the presence of the jury, the state would like to revisit the identification of the decedent, specifically Christopher Thomas. Your Honor had previously ruled that we could not, without proffering to you what we've done.
What? I'm sorry.
If you recall the arguments previously when the defense cited case law, Your Honor was asking us what effort we made to utilize a non-family member for purposes of identification of decedents. So we have at this point subpoenaed multiple witnesses, including, for instance, Travion Glass, who's refused to come to testify. We've also subpoenaed Patrick DeLoach, who has had unsuccessful service on. We've subpoenaed Frio Bang, whose legal name is Frederick Gibbons. He has refused to comply with subpoenas, and his attorney, City Davis, who had previously accepted service on his behalf, has now no longer accepted service on his behalf, so we're unable to bring him in. And there was an additional witness who we have not been able to serve, Jacoby Mills, we have not been able to serve. At this point, the state is re-arguing and we're requesting that the court allow us to use the family members as the only credible witnesses that the state has to identify the decedents. Today, specifically, we could call Leandra Phillips, one for the purpose of identification, but also for other testimony. That's all.
Thank you.
Your Honor, we find it to be disingenuous to make the argument that witnesses that the state has been unable to contact for the last 3 years, and they know they have, to say, but we really have been trying while we've been in trial, as though those 4 people who they know to be unavailable are the people that comprise the universe of people that can identify the 2 decedents. That's clearly not the case. For there to be a good effort, a good faith effort to identify somebody who's not a family member, they should maybe broaden their search to somebody that the family might know, maybe a very distant relative, something of that nature, as opposed to the 4 witnesses that they know that they have been unable to reach for 3 to 4 years. To now come and say, we're really still trying to reach them, Judge, is not passing the hurdle of good faith effort to find somebody other than a family member to testify. That is assuming that these are the only 4 people they know. And they already know that they can't find these people because they haven't been able to find them for 4 years. So to now come and say, we still can't find them, but we really have tried for the last 2 weeks, is not moving the ball an inch.
In addition to that, Your Honor,
Yes.
in addition to that, Trevon Glass is scheduled for deposition tomorrow. The state informed us just recently, during the lunch break, that they anticipate he'll be here for deposition. So it's a little immature for them to bring up premature. I'm immature. To bring that up now.
Hey, Counsel, have you discussed with your witnesses the possibility of identifying their family members?
Yes, Judge. In fact, that was the reason we sought out Travion Glass after obtaining his address. You specifically told him that we would only be calling him for the purpose of victim identification. He said even that he would not be willing to come and testify due to safety concerns. If Your Honor also recalls Ms. Bradley, when Felicia Holmes was on the stand, she indicated that although she had met the decedents, that she was unable to identify them and unwilling to do so. The case law doesn't require the state to search the universe to be able to make an identification. We're proffering to the court that based on the discovery, based on our review of the case, we have no other credible witnesses that can identify the decedents.
My question though is, maybe I wasn't clear enough with my question. Have you talked to family members about when they, assuming they testify and they are able to identify their loved ones, that it's basically concerning about what type of emotion they show and reflect, and we're looking really for more like an analytical, not some type of emotional response.
Absolutely, Your Honor. I spoke with Ms. Phillips previously when we had first addressed this. I will remind her. In fact, Ms. Bradley offered to the court that what we would do to minimize any sort of emotional response from the family members is that we would not even show them the photographs while they were on the stand. The photographs are actually already in evidence. So what I can do is just, having already previously shown her outside the presence of the jury, I would ask her to identify the any number associated with that photograph and identify her son. And just for today's purposes, we would be only using Ms. Leon Phillips.
Yes, number one, the rule wasn't voted. They never brought that to the court's attention to get permission to allow any witness to remain in the courtroom. If the court recalls, at the very beginning of this trial, we discussed Jamie King, the mother of our client. And the state said they were not going to call her and had no objection. But we brought it to the court's attention immediately because we wanted permission of the court, because she was listed as a state witness at one period of time. Now, I know they weren't going to call her because they gave us a Brady motion response indicating that she was under criminal investigation, which would indicate that she would invoke her Fifth Amendment privilege concerning this matter, or any matter. But we did bring it to the court's attention because of the rule. And now to hear that a witness has been sitting in this trial from day one, apparently.
As you think that's going to create the witness or fashion her testimony
I don't
in
know,
such a way?
I don't know. I'm not.
To your deposition, I think.
Yes, they did take her deposition, but not on legal ID. And nothing, I don't know what else they're going to profit.
Judge, in her deposition, she identifies the decedent's her son. Further, Judge, as Your Honor is aware, Marcy's law allows the next of kin to remain in the courtroom during the proceedings.
Thank you.
Yes.
I'm not trying to belabor this, but certainly I've not heard any inquiry from the state to the mother or the parents or any close relative if they know of any of his friends or any distant relative.
My experience suggests that more than half the times that this issue comes up, that there's a stipulation. I understand the defendant doesn't have to stipulate the identity of the alleged victims, but typically it's done by some agreement or stipulated. It wasn't done in this case, that's fine. You raised it earlier, and I said, that's fine. See if you can get somebody else. Counsel just explained to me they made a good faith effort to get somebody else to be able to testify. That hasn't happened yet. There's a lull in the proceedings. They want to move on and cross that T, dot the I, and have the alleged victims identified.
I also want the case to move on, but quite candidly, they have not even inquired from the family about any distant relative, or I've not heard any proffer from them, or any friends of his that could come in.
I just heard her indicate 3 or 4 people that she.
Those were all state witnesses that they have not been able to locate for 4 or 5 since the inception of this case. They've all been implicated, and I would suggest to you that one of the problems they have is that they could be charged with a crime. I don't represent them. I don't profess to represent them. I have not met them. But the witnesses that they have spoken about are all individuals that were at the studio or in one of the cars.
What's your concern about a family member identifying a victim.
Well, I think the case law is clear. That's frowned upon because of the potential problem,
And what's the potential problem?
the emotional problem that would cause a mistrial. And we've now been in this.
Didn't counsel didn't I just indicate or ask counsel to advise me if they've spoken with the family member who's going to identify, and they've indicated and they're going to do whatever they can to minimize it. They're not even going to publish the picture at the same time, is the way I understand it.
Well,
right? So
Yes.
I'm passing counsel respectfully. I understand your objection. I asked the state to see what they could do to get a different witness in. Apparent to me that they've tried. They're unsuccessful in that area. You think greater efforts need to be done. But we'll let the family member, again, is going to identify or indicate to the family that they're not to have any outbursts of emotion or anything like that. And just we're going to move forward.
Understanding. The other component of the emotional and sympathy factor of relative testifying is the juror hearing the voice and seeing the family member and thinking and developing a sympathy and maybe feeling like they owe them. So there's, even if they don't become emotional, the risk of that happening does exist.
When they show autopsy photos and everything else, there's all types of, and the jurors are explained to try to, you got to separate the emotion from it. It's part of the jury instruction that we give at the later time.
Just note,
Serious case, and it's certain pictures and certain things are emotional. And the jurors are explained that in the instruction that they're not to let emotions play a role.
we understand the court's ruling, note our objection, and we certainly don't want to stand up and object of this testimony in front of the jury, because I think that draws more attention. So if the court will allow us to have an objection to this.
Do they have any objection to it? Standing objection?
Just for the record, Your Honor, they might as well say they look for Jimmy Hoffa because they made no effort beyond what they already know, or they just came and voiced the name of people they haven't been.
Like a tandem thing. I thought we talked about one attorney making the argument. It goes back and forth all the time.
Just want to make sure we have a complete record.
Well, then talk to yourselves about it beforehand, but one attorney making the case, she's arguing for the state on this issue. One of you should be able to argue the issue, not have both of you come back and one after the next, all right? I've ruled.
Thank you, sir.
Let's bring the jury in. Ladies and gentlemen, thank you. Trust you had a nice lunch. We're going to reflect the presence of our jury, the defendant, the counsel, and assistant attorney.
Your Honor, we're going to call the witness. At this time, we are closed.
Phillips, please. Ms. Phillips, welcome. Come on up here, please. When you get back here, what I'd like to do is remain standing. Raise your right hand and be sworn.
You solemnly swear or affirm the testimony that you shall give in this case shall be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Please state your full legal name for the record.
Leander Phillips.
Please spell your first and last name for the court report.
Leander, Leondre Phillips, Phillips.
Thank you.
Please have a seat. Ms. Phillips, that microphone will go up or down, but doesn't move back and forth. Okay. Now you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Phillips.
I heard you.
Can you state your name, your full legal name, please, here?
I'm Leon Phillips.
And are you related to one of the decedents in this case?
Yes, I am.
How's that?
I'm his mother,
And who is that?
Christopher Thomas.
And you have previously been shown outside the presence of the jury a photograph with ME number 18-3119. And that was a head photograph. It's now in evidence under States 75. I believe it's photograph number 4. Who was that? Were you able to view that photograph?
That was my son.
If you recall, we showed it to you previously, the headshot with the medical examiner's number.
Who was that in that photograph?
Christopher Thomas, my son.
And also,
Publishing states 7.
positive 21915. Ms. Phillips, did you see who entered into the occupants who entered into that gray Jeep?
Mhm.
And is that a yes?
Yes,
Do you recognize where your son entered that gray Jeep?
yes.
Which seat, if you can identify for the jury?
He got in the back seat on the right hand side.
Did you recognize the individual that got into the back seat on the left side, the rear driver's side?
Yes,
And who was that individual?
Janelle.
And Jamal, is that the defendant, Jamal Demons?
Yes, ma'am.
And do you know him by another name?
Melly.
And do you see Melly Jamal Demons in the courtroom?
Yes, I do.
And do you identify him by article of clothing and where he's sitting in the courtroom?
He's sitting over there. He had on a tuxedo. Or I think it was.
Your Honor, let the record reflect the identification of the defendant by this witness.
Record shall so reflect in court identification of defendant.
Nothing further.
Ms. Phillips, we want to express our condolences to you.
Thank you.
Nothing further.
Thank you. Sit down. Thank you.
I'm the case going to publish 61, state 61.
Judge, can we approach?
That was actually heartfelt because they actually didn't have to do that. So I'm really happy that they said that to that lady because I can't imagine how it feels to lose a child. But baby, having to sit there across from somebody that you think did it, different type of love.
Publishing photograph 1. Photograph 2. Publishing video 1.
He didn't do that. Ben, I was the same people.
Publishing video 2. Video 3. Publishing now video 4. Publishing video 5. Publishing video 6.
Like, you know you come back.
Publishing video 7.
All right, this is it ain't the most important shit here.
Publishing video 8.
Right now.
Publishing video 9.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Publishing video 10. Publishing video 11. Publishing 12. Publishing 13. Publishing video 14. Publishing photograph. Another photograph. Third photograph in that series. Fourth photograph. Fifth photograph. Sixth photograph. Seventh photograph. Eighth photograph. Ninth photograph. 10th photograph. 11th photograph. 12th photograph. That's the end of stage 61. Just publishing now from State 64, the previously shown photographs to defense counsel. Photo 1. Oh, I'm sorry, State 64. Photograph 2. Photograph 3. Photograph 4. Photograph 5. Six. I'm sorry, 6. 7.
7, 8, 9, 10, 11, 12, 13, 'I'm going to use the other computer. It works a little bit better with your just a momentary delay. Fifteen. 16. 17. 18. 19. 20. 21. 22. 23. 24. 25. 26. 27. 28. 29. 30. 31. 32. 32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 48.
All right, so she about to be going through photos for a long time. Are y'all good with just skipping these and jumping back to court? Because literally, for the next 20 minutes, she's getting ready to go through photos. Okay. Okay, Chloe, because what? Okay, let's skip to court because maybe we don't. We absolutely do not need to see you go through each of these photos.
Jury entering.
Open Snapchat. They should. However you want to interpret it.
John, thank you. Please be seated. Let the record continue to reflect the verdict of the defendant. The counsel, the assistant attorney, ladies and gentlemen, the jury. Ladies and gentlemen, I think that the state was missing this publication, certain photographs. What exhibit number is this again?
64, the instruction of the negative subtotal.
Thank you. You ready? Thank you.
$240. 241. 243. 244. 245. 246. 2:50.
All right. Thank you, ladies and gentlemen. Have a nice morning. You can open that on your chair. Thank you. Let the record reflect the jury step down. Counsel remain along with the defendant. So you said there's more that you have to publish to the jury?
Yes, there's other videos on the seat, many videos that in phone. The defense counsel needs to go over and I have to show them exactly which ones and we have to go through those and then we'll have to read.
How long are the videos?
There's tons of them, Your Honor. So I have to prove it's the defendant's phone.
Thank you. So, how are we gonna handle this? You want to, have you seen the videos? I take it, I mean, you have them there, set over discovery, correct?
Yes, but they're now isolating those that they intend to, and we'll make sure that we do what we need to do during the time limit. I don't think we need the court's,
Well, this is my thought. If there's an issue about it, I don't want to have a problem with it. My thought is if there is an issue about it, we'll resolve it and we'll do it on some date next week when we're off. We just pick a date that that everybody's good for and we'll resolve it that during that week if there's a problem.
makes good sense to me.
What night we have Friday? Friday issue? Any issue Friday? I know we have hearings.
In terms of the 6th, I believe I scheduled a depot for their defense witness.
I want to ask you about that too, but let me, I just want to find out, make sure we need time on that Friday. That is the 14th, I guess.
The 7th.
Right.
Yeah, so.
The 7th.
I apologize. I'm looking at the time. You're right.
7th is the time for the statement.
So could we clarify because we were supposed to a date today for the deposition and now she's saying she's scheduled for 6?
No, we were talking about the seventh.
We're gonna get the depositions at 7.
Okay.
So, counsel, on the 7th, are you, everybody's available on the 7th if we need it? So how much time do you think you need?
I have
Let's get to day 12 and see if we get some court. Because she said she got tons more of photos to go through and videos to establish that this is his phone, is what she said. I thought it was the Snapchat, but it appears that they're using the Snapchat as evidence that it is his phone because the phone is logged into the Snapchat. So let's see where we go from him. Just kind of preview it for a second to make sure. Okay, we got witnesses up here. So let's get on back.
Yeah, last night I back to see made in open court as
Okay, that is the them.
made in open court as to how it would benefit the jurors. It is separate and distinct from the other items. In fact, the state would submit, the state could offer the entire car into evidence because it has been preserved. It has been the same condition since it was initially put forth. And that would, there is no limitations in the evidence code as to the size of the piece of evidence. If it doesn't come in through the courtroom doors, Your Honor, the state would submit that they would have to make arrangements for the jurors to be able to view the item of evidence.
I did file a response, Your Honor, were you able to read?
Yes, ma'am, I'm sorry. Anything else?
I would just add that we have yet to view the car ourselves. We're supposed to go see the car this afternoon after court. But as I set forth in my motion, I believe it's overkill. The witness testified to the specs, the measurements in the car. We actually have photographs that have been moved into evidence that have measuring sticks that clearly show you the distance in the car. Her proposition that we need to see the car so they can see the purview, I guess she's finding out the jurors sitting inside the car, which makes no sense because they don't have the same measurements as the decedents. Moreover, I'd like to point out, we don't even know where the decedents were truly sitting because there are no crime scene photos that actually show them being in the car at the hospital. All the pictures that we were shown are of the decedents, the car being empty. So I would even argue the proposition of what she's trying to say, this person sitting here and this person sitting here. There's no actual evidence.
Judge, there was a motion filed at 5:54 p.m. last night, and back to the same second witness. I don't know if Your Honor wants to address it this morning, in addition to the same second motion.
or you want to do it after the first one, it's going to be fairly short.
Tell me what the issue is now.
So this speak on Friday afternoon after Mr. Glass's deposition policy, second motion and reading. Does Your Honor have a copy of that?
I had a motion from me that's filed by the state. I don't know which one we're talking about. I read it. Yes,
I emailed it to Your Honor's JK on Friday, it's titled State Second.
yes, I read it.
That's what we're requiring. So there are three motion and readings. The first one is regarding the defendant's essentially self-serving hearsay statements for the deposition of Mr. Glass. Counsel asked Mr. Glass whether or not the defendant had ever admitted fault essentially in the incident. So that would be a self-serving statement that the state would seek to exclude, in addition to any other self-serving statements during prosecution.
Anything else you want to talk about?
Yes, that's the point one. Second, prior bad acts. As to the witness, Mr. Glass, any prior arrest that did not result in any convictions. In addition to, counsel brought up a alleged shooting incident that was denied by the witness. And there was also allegations of him being, just generally involved in that act. So we would need to exclude any of those. He does have 2 prior felony convictions, so those would be what counsel's testimony should be limited to. And finally, the drug use, which I cited to Edwards versus State, which is 548 Southern 2nd, 656, Florida Supreme Court, 1989, regarding when counsel can inquire from a witness whether or not he's utilized drugs. The witnesses admitted and did admit in deposition that he did smoke weed on the date of the incident. But however, counsel did inquire as to his general drug use, and so the state would need to exclude any general drug use that's not related to either the date of the incident or, according to Edwards versus State, any other testimony that would affect his ability to recall events. And those are the state's 3 motion amendments.
What's one motion limited, but 3 paragraphs?
Yes, 3 paragraphs, yes.
Thank you. Professor Steer.
Morning, Your Honor. As to, I'm trying to recall, as to the issue of drug use, I'm not thinking that it's our intention to date his drug use back to birth. However, we know that one of the lasting and long-term effects of chronic marijuana usage is affects one's memory. So the fact that I think when he was asked, "Do you smoke marijuana?" his answer was yes, and how often? The answer was whenever I can. I'm not sure that we should be limited to the date in question, because the impact of such chronic use, whenever he can get his hands on it, impacts his ability to recall matters. With respect to his prior bad acts, there are 2 felonies which clearly are impeachment. And beyond that, however, he was charged. This is a witness who made himself deliberately unavailable to the parties for years. He then gets charged in May of this year with a crime, and now and then watches the proceedings on television and has suddenly made himself available. That goes to bias his intent.
I don't think the state was suggesting that you couldn't ask questions about whatever current charge he has. Are you suggesting that?
No, Judge, I didn't address that. He can ask about the charges, about the maximum minimum penalties, and I would agree that he could ask whether or not he's been heard in favor in exchange for his testimony as it relates to that.
With regard to the current charges.
Correct.
And well, if the state's position is you can't impeach him with anything beyond the current charges and his felonies, I can't remember what the first one was.
So self-serving hearsay statements of your client.
First of all, it's not a statement. A statement are utterances. The question that was put to the witness was whether or not Mr. Demons ever admitted involvement in the activity. The answer is no. There was a time during which the witness indicates that he was inquiring of various people what may have happened. And him saying that Mr. Demons never admitted involvement in the offense is not him uttering a hearsay statement. It's him denying the existence of any statement, hearsay or otherwise. So I don't think there's a hearsay exclusion to the failure to admit involvement in the offense. So I don't think that that question ought to be put if in fact we decide to put it to the witness.
Thank you. Well, regarding the first issue about the witnesses alleged testimony that the defendant, Mr. Demmons, didn't admit to him that he was involved in it. That's not something the witness observed or anything. That's in essence, that's in essence an exculpatory statement. I agree with the state. You can't do that. Granted, regarding the prior bad acts and impeachment, we're all on the same page. You can ask about whatever the pending charge is. You can talk about that in prior to felonies. But as to other uncharged offenses that may have happened along the way, those are not, can't inquire as to those. As far as the drug use, if he's using marijuana, cannabis at the time, that's all fair game. I don't see any issue with that. And if he uses it frequently, I don't see any issue with that either. It's, I don't know that that's the type of, it may have been one time. It's stayed consistent for a while, has effects on him. I think all that's fair game. I don't have any issue. And I understand Edwards talks about when you're under the influence of something, but if it's over a period of time, I've heard from various experts how long stays consistent can do it, so it can be for a period of time.
Okay, and just to clarify, my question, like period of time from the date of incident to current date, or even predating the date of incident?
Counsel, to me, it's fair game. They can go into it.
Okay,
I don't have any issue with it. All right.
And Judge, the defense did file a motion to exclude Trevion Black from testifying at all. I don't know if they want to or your Honor wants to address it at this time.
We can address it at this time.
Sure, go ahead.
Did you have a chance to read my motion and the case law this morning?
I did.
All right.
Thank you.
So it's basic, as I stated in my motion. After 4 years, we're finally able to depose Mr. Trevion Glass. Interesting enough, as I set forth in my motion, and I attached the pages of his transcript, he states that it wasn't until he started watching YouTube because his case was live streaming and hearing his name repeated everywhere that he decided to call up the prosecution. As I further stated in the deposition, specifically questions were asked about his independent recollection of this incident, and he clearly states, let me go to it. I wasn't aware who got into what seat that day, but from me watching what's going on, yeah, I know now. Yeah, Mr. Howard then clarified that. Watching what's going on, you mean the trial proceedings? He said, correct. Looking at this rule of sequestration, and we know it here as the rule dates back to biblical times. And going back into there, it's been well established that we need these protections of this rule of sequestration to prevent witnesses tailoring their testimony to match the testimony of the previous witnesses. And that's exactly what we have here. 2023, in the Bible, they didn't have a TV live streaming into the courtroom. So most of our rules, when we were dealing with it, were saying, you cannot sit in this gallery and then come up on this stand and testify. But if he's sitting there watching from that TV, from the comfort of his home, there is no difference from him sitting here in this gallery and then getting up there and testifying. That is the crux of this rule, and that is exactly what it is meant to prevent. Sequestration of witnesses is one of the oldest and most time-honored rules in the court system. It's to ensure that we have effective truth-seeking. And we won't have effective truth-seeking if he's allowed to sit here, watch everybody testify, and get up there and then tailor his testimony to the last 3 weeks of evidence and other witnesses who have testified. I provided the case law. I think the law is clear. Reading into that case law, because this rule of sequestration, we do have a sister rule in the federal court system, 615. And they've actually gone on a little bit further with their cases to give us examples of out-of-courtroom communications that are not allowed. And they give us examples of witnesses sitting outside of the courtroom talking about what they testified with another witness who's going to testify. They talk about giving witnesses the transcripts of other witnesses and preventing them from testifying. In this case, again, he watched the entire trial. We don't even have to guess about this because he tells us in his own deposition that he's been watching this trial, that he's heard his name in this trial, and that's why he's decided after 4 years to come and testify. He must be excluded to guarantee my client a right to fair trial.
Thank you. What's this say?
And just, the exclusion of the witness is the harshest sanction that this court can impose. The state acknowledges there was a violation of the rule of sequestration. The witness indicated so in that position. However, counsel's representation that he watched the entire trial is wholly inaccurate. That's not what his testimony was. So the court must determine whether or not it was an intentional violation, whether it was inadvertent, or whether it was any bad faith on part of the witness or the state here in particular. The state would proffer that it was an inadvertent violation, it was unintentional on part of the state. As your honor is well aware, it's been documented that Mr. Glass has not been cooperative with the state. We tried to subpoena him pre-trial. In fact, the first time the state spoke with Mr. Glass was after his current arrest, which I believe was in June of 2023. After the state contacted the witness for the first time and was able to speak with him after we had already began trial testimony. The witness indicated to me that he would not be here, he would not come, and he would not cooperate with the state subpoena. He did cooperate that in his deposition, that he did in fact inform me of that information, and therefore the state operated as he was not going to testify. It was not until the defense subpoenaed the witness that he became compliant and came in on Friday. I think the first time he came to Broward County and the state met with him was on Thursday of last week, which I believe was July 6th. So the first time the state would actually had an opportunity to even speak with the witness in person and inform him of the repercussions of the rule of sequestration was well after testimony had begun already. And the prejudice that the defense has cited in their motion is essentially that he's watched the video surveillance, which is currently in evidence in state 7, and has changed his testimony based on his review of the video surveillance. So two things: he did give a statement to Detective Moretti back on February 26th of 2019, and he indicated that he got into the backseat of the red Mitsubishi. He's now been refreshed, and his memory is now refreshed that he did in fact get into the front seat and not the back passenger seat of that red Mitsubishi. The state would proffer that prejudice is minimal, and the reason is because we have video surveillance. And so Mr. Glass, in and of himself, can be impeached based on his prior testimony saying he got into the back seat versus the front seat. And that's the only prejudice that the defense has outlined in his deposition testimony that has been colored by his view of any of the trial testimony. And so based on that information, one moment, Judge. The state would say that rule of sequestration for this court to exclude him completely as a witness would not serve its purpose. It's not a per se rule to exclude. The trial court has discretion, and I would ask you to exercise discretion because there's less intrusive means, being one of him being impeached based on the inconsistency itself.
You have the transcript of this witness?
I ordered a copy and we did not receive one. If counsel can be so kind as to also provide us with a copy, we have received our copy.
Any problem with that?
No, I can email it right now.
All right, so could you give a copy of that to Travis?
Yes.
And what I'll do is I'll make it, I don't know if I'm allowed to make copies.
I can email to Ingrid, and then I can email to them. They have their copy machine right there. I do have one quick follow-up, Judge, if I may.
Sure.
So there is a line of cases, and counsel is arguing from the line of cases where the defense has violated the rule of sequestration. So when it's a defendant violating the rule of sequestration, you do have to go into a Sixth Amendment analysis because it's his constitutional rights that the court still has to protect. And that's why you have that stringent standard. However, when you're dealing with the prosecution violating the rule of sequestration, then it becomes the question of my client's rights to a fair trial. And that's how the analysis should go. And you're looking at those line of questions. When you go to 96.16, there is another section that comes down that gives exceptions to the rule of sequestration, which we see. We have the witness's family in here. Why are they allowed in here? Because of 96.16 gives that exception. But there's case law that says when that family gets up there to testify, Mr. Demon's client rights to a fair trial will trump the other people's rights in this case. In this matter, Mr. Glass doesn't have any rights to be in this courtroom. He has no right to be watching this from TV or his testimony to the evidence. I would ask him to look at this in the light most favorable to Mr. Demons and his constitutional right to a fair trial. And that's what we want today. And it's not going to happen with a witness who's been watching this proceeding from the comfort of his home.
But the defense isn't suggesting that this was all some type of connivance with the state, that they planned this or executed in some fashion to get around the rule of sequestration. You're not suggesting that. You're suggesting that you shouldn't be allowed to testify because it's a violation of the rule, which the state's agreeing it's a violation because the rule of sequestration was involved. But you're not alleging or suggesting the state had anything to do with it, are you?
So, Judge, and I did ponder this last night, and for the sake of being a professional, I did not come with a motion for prosecutorial misconduct. But as we've heard Ms. Smith admit herself that she sat in that deposition with us, and they too realized that he had been watching the trial from his own testimony. The simple fact that the state now wants to even put him on the stand is knowingly, Judge. They knew in the deposition, 1. 2, they knew when I put him on notice with my motion. So they had the opportunity after the deposition, 2, after my motion pointing out we violated the rule of sequestration, just not to call them. They, however, are going to continue to proceed knowing he has violated the rule and put him on the stand. So yes, when we look at it that way, the state may be acting inappropriately.
Thank you. And counsel, from your perspective, as far as the state's concerned, once you found out this witness was going to, his location was found and you gave his address over, and I know you said that he wasn't going to cooperate. I think you made that representation over the board a week or so ago as well. I don't know the exact date, but you made a representation to that effect. When was the first time that you advised the witness that the rule of sequestration was invoked?
Judge, last Thursday, because prior to that, I had only spoken to him on the phone, and he had told me, we essentially had abandoned almost calling him as a witness absent a decision to do a rule to show cause, which we had not decided at that point. So when he told me he wasn't coming in, I had no further conversation with him until he contacted our office, and that was in response to the deposition. And counsel's essentially,
What date was that?
I can have counsel look up the exact dates and let you know, because we have an email when he contacted our office.
That's the time that you told him the rule was invoked?
No. He called our office indicating that he had gotten a subpoena and whether or not he needed to appear, which we indicated, yes, he did need to comply with the subpoena. We tried to make arrangements for him to come. I believe his deposition was scheduled on a Tuesday, if I'm not mistaken.
No, that was the deposition that was set, I don't know if you recall, without any discussion or scheduling with the state for that Friday.
So it was set on a particular day and he failed to appear that day. And then I called him when he failed to appear while defense was still in state attorney's office in the lobby. I said, "Are you in Broward County right now?" He said, "No, I'm not. I don't have a ride." I said, "Okay, transportation is arranged. Can you make yourself available?" He said he would. He called us, he told us he would be in Broward County, I think Thursday afternoon. He called us on Thursday, said he was in Broward County, and that was the first time we met with him in person. And I would say, Judge, the defense is asking you to essentially apply a per se rule. The case law says there's no per se exclusion for the rule of sequestration. The only thing she's saying that's been affected is his seat position in the Mitsubishi car. That seat position is on video, it's in state 7. And so that's something that the state can even show the witness in preparation for his testimony. It's something he would publish during his testimony. So that contradiction between where he sat in the car is not of the sort that should exclude his entire testimony and would color his testimony.
Thank you. Where's my question though, as to when you first advised the witness?
Thursday, Judge, when we met with him in person.
Last Thursday.
Yes, Judge, when we met with him in person for the first time.
Thank you. All right, I'm for ruling on it. Just, I'd like to read the transcript.
So, Your Honor, I think the case law is also clear that you need to read his initial statement to see if there's been any change in his statement from the initial statement to the deposition.
And I'm going to provide, I can approach Your Honor.
Where's the case law?
I would like your hand in case law. I'm providing the statement, so I can provide it to the judge.
I have the statement. I want to see the case law you're quoting to because we're talking about excluding him. I didn't see any case law. It says
I only
substantial.
decided that the case law council, they just decided the rule. But let's do this though. I'm not done with this yet. I want to read what he said, as well as a statement. I want to take a look at those things.
May I approach, Your Honor?
Sure.
And so the case,
It's Danny Benitez, he's a record custodian, so we anticipate it's going to take about 5 minutes, which is why we.
Search Mitch Wood said that.
Mr. Glass.
Where's this Detective Murray?
He's also going to be in this afternoon.
and Judge, I'm going to print out the copy of the case law that the state is citing to, which I'll print out a copy for counsel and for Your Honor.
She just said, she got notes on it. I don't want that. Did you have your notes on that? I'm not.
So I'll take this. It's just the
I'm
last.
sorry, can you just email it?
I'll do it right now, Judge.
Thank you. She'll print it out. I would like to read it. And we'll just have it marked as a court exhibit for the purpose of this, so.
States otherwise ready, Your Honor, to proceed with the first. Danny Benitez, record custodian and non-custodian school.
And Judge, we do need to do one quick order to keep state 64 under seal for the purposes of the clerk. There is sexually explicit photos of minors and videos on there, so that must be, the clerk needs to be aware of that on the 9807. That's the 9807. Mr. Dean, Mr. Dennis.
Any objection?
No objections.
All right, go ahead and sign. I'll sign. Thank you. All right, Brittany, you also ready to proceed?
Yes, Your Honor.
Defense?
Yes, sir.
All right, let's bring the jury to you. Jury entry. Okay. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, Mr. Devon, his counsel, the assistant state attorneys, both ready to go on the jury. Hope you had a good week last week, and we're back on, so I think the state is still on its case in chief. Can we record your next witness, please?
Yes, Your Honor. The state calls Danny Benitez.
How long is this? How long is it?
3:40 to approximately 5 a.m. We would be intending on publishing the entire thing for the jury. But just so it's clear, this was previously provided from the records for two defense counsel. We just now, as I
in Hundred Pines, Florida.
And have you been employed with the Montessori school in one capacity or another since October 26, 2018?
My wife and I started school in 2002, and up until today, we're still involved in the school as director of school. I'm the operations director of the school.
And back on October 26th of 2018, were you you and your wife the owner and operators of that school?
Yes, we were.
Okay. And the Montessori school, where's the specific address?
The address is 19200 Pines Boulevard, Pembroke Pines.
And you mentioned that's in the city of Miramar, correct?
Yes, I have.
So at some point in time, you provided video surveillance from your school to law enforcement, either 2018 or early 2019.
Yes, I have.
And how long is the, the system, how long does the video maintain until the system overrides naturally?
The system actually maintains a backup for 90 days and then overrides itself with the oldest of the events being raised.
Okay. So in order to preserve video surveillance, you would have had to capture it and preserve it within that 90-day window, correct?
Correct.
All right. And you've had an opportunity to review the video surveillance that was provided to law enforcement and then placed on a USB?
Correct.
Right. Your Honor, at this time, we're showing the counsel with the pre-marked as states quadruple H, so H. May I approach the witness? He says, is this the USB you were able to review?
Yes, it is.
And how are you able to recognize this particular USB?
Well, it has my initials on the back.
Okay. And did you sign an initial in after reviewing the video surveillance?
Yes, I have.
Is that video surveillance a fair and accurate representation of the video surveillance that was captured back on October 26th of 2018 from from the Montessori School's video surveillance system?
Yes, it is.
And that video surveillance was maintained and kept by Montessori School until it was turned over to law enforcement?
Correct.
And it's routine for you to maintain that system? In fact, you still have a system to this day?
Correct.
Your Honor, at this time, the state will move into evidence what was pre-marked as H, quadruple H, is the next number included, I believe, 82.
And we're gonna object, Your Honor, we're double checking all of the sessions.
Excuse me, just one second. We're letting the jury step down. Counsel Rand, while the defendant, you want to play the video now? Show counsel the video on how long is it? How long is it?
3:40 to approximately 5 a.m. We would be intending on publishing the entire thing for the jury. But just so it's clear, this was previously provided from the record for two defense counsel. We just now, as sidebar, learned that they had not been able to watch it and the file was corrupted. They had not told us or asked for an additional copy in any way, shape, or form.
Can we just take care of that sidebar? Didn't I ask him that?
Yes, sir, but I make sure the record is clear on the state part of that. In addition to the other images and things that she discussed in videos, those were from the phone, and those were available for defense. They were in my office on Friday afternoon. As to the things I said I would email, that was the PDF of all the photos that were published in open court on Thursday afternoon. Just so it's very clear.
Okay, I'm back here right now with trial attorney Janine Atamian and federal law attorney Gwen Marie Davis Hicks. Gwen Marie, I'll start with you. What an interesting morning, right? So we start off with all these arguments back and forth between the attorneys and the judge regarding Mr. Travion Glass. Then this witness comes on the stand for like 30 seconds and they have to go back and see what this video looks like. What do you think about what's happening?
Mr. Liberty, did you get an opportunity to take a look at the
Yes, Your Honor, thank you.
video for review? All right, so is there any objection?
No objection, Your Honor.
All right, so we'll do this again from the jury. So bring the jury in, please. Your next witness, please.
Trevion Glass.
I'd like you to do is remain standing, raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give in this case should be the truth, the whole truth, and nothing but the truth? Please state your full legal name for the record. Please spell your first and last name for the court reporter.
T-R-E-V-O-N.
Thank you.
Please have a seat. Mr. Glass, that microphone in front of you will only adjust up or down. It doesn't move back and forth. All right, so if you could scoot up close to the microphone. All right, you ready to proceed, sir? Counsel, you may.
Thank you, Your Honor. Good morning, Mr. Glass.
Good morning.
And I know you're quite soft-spoken, so I'm gonna need you to speak out a little louder, okay? And remember, you have to make oral responses, okay?
Yes.
How old are you?
23.
And where are you currently living? What city?
Real Beach.
And have you lived there all your life?
Majority of it.
Okay. You completed high school, or what was the last grade you completed?
11.
Right. You're not married, correct?
Excuse me?
You're not married?
No.
So I'm going to talk about some prior stuff before we get into why you're here today. Have you previously been convicted of a felony? Yes or no?
Yeah.
And how many times?
To my best knowledge, once.
Okay. If I were to show you something, would that refresh your recollection?
Yeah.
A prior judgment? Permission to refresh the witness?
Show counsel first, please.
Yes. I'm going to ask you to just look at the document, don't say anything. Okay? Have you had an opportunity to review the document? You have to answer.
Yes.
Right? Is your memory fresh as to how many convictions you have?
2. What was that one? Everyone? I don't know shit. Let's see, 2 charges.
All right. Now, you currently have some pending charges in Indian River County, correct?
Yeah.
And those are 2 charges?
Yeah.
Misdemeanor resisting without violence?
Yeah.
And an obstruction of service or execution of a search warrant?
Yeah.
Are those misdemeanors or felonies?
I'm not sure.
Okay. Do you know what the penalty you're facing on those charges?
No.
Okay. Have you been offered probation in that case?
Yeah.
And have you been made any promises in exchange for your testimony here today?
No.
Right. So let's go back to October 26th of 2018. What were you doing like for work?
I wasn't working at all.
All right. Were you involved in the music business at all?
Kind of, sort of.
And how so?
Making beats.
All right. And when you were making beats, were you working with a specific group or music group or people?
One person to be particular, but yeah, supposed to be in the group.
All right. Let's start by saying this. What group was it?
YNW.
All right. And when you said one person specifically, who's that person?
Julie.
Okay. And can you tell the members of Judy's real name?
Christian Thomas.
And how long have you known Christopher Thomas, who you refer to as Judy?
Over a decade.
Okay. And this is back in October. And did you know somebody by the name of Anthony Williams who went by Sack Chaser?
Yeah.
And how long have you known Sack Chaser?
A couple years.
All right. Your Honor, permission to approach the witness with state 73.
It's in evidence, yes.
Yes.
You may proceed.
Again, I'm going to ask you to take a look at state's photograph number 4 and state 73. Do you recognize that person in the state's photograph with the label marking 18-3118?
I do.
And who is that?
Anthony Williams.
So, back on October 26, 2018, do you recall being at the New Era studio?
Yeah.
Who were you there with?
Few other people.
Okay. Was Judy and Sack there?
Correct.
All right, and do you recall around what time you guys got to the studio?
I'm not sure when we arrived.
Okay.
I don't.
Was it light or dark outside?
I believe it was dark. I'm not sure.
All right, and what was the intention going to the studio?
I believe we were supposed to have a 12-hour session.
All right, and that's a 12-hour recording session, right?
Yeah.
And who was the artist that was recording that night?
Really, everybody was artists. Anyway.
All right, did you guys end up staying for 12 hours?
Nah.
Okay, what changed and why did you end up staying?
So that's my knowledge. People were sleeping, so we ended up going home because sleeping in the studio.
All right, and part of that is because studio time is obviously it's costly, right?
Objection to leave.
Stay.
Okay, you just said it was paid for. What was paid for?
Studio time.
All right, so you guys had prepaid for 12 hours.
Correct.
And obviously not utilizing that 12 hours, is that a waste?
Objection, Your Honor.
Stay.
The meeting.
I'll move on. How long, well, you said that people were sleeping. Who was sleeping?
Everybody but me, Anthony, and Chris.
All right, so who was upset that people were sleeping?
Objection, leading.
Who was upset overall?
There was no testimony that anybody was upset.
Okay, rephrase your question.
Is someone upset that people were sleeping?
I guess you could say that, yeah.
And who was that person?
Sad.
Okay. And how did Zach respond? How did Zach respond to people sleeping?
Woke him up and let him know it's time to go.
All right. And how did he do that?
Yeah, he went and woke him up, shook him up.
All right. Was there an occasion where he threw water on some people to wake them up?
Objection, Your Honor.
Stay.
Your Honor, this is deliberate. Can we go
Excuse me.
sidebar?
Counsel, if you make an objection, make an objection. Don't be arguing in front of the jury. I told you that before, all right?
Can we go sidebar?
No speaking objections.
Can we
Come
go
sidebar, sure.
Thank you.
Ooh, so is she trying to say that Seth caused the issue with them inside the studio? Like, what you getting at, girl? But you know you was wrong for asking that question. Or did you ask it though? She know she was wrong for that.
Okay, so at some point you just mentioned that you guys were getting ready to leave the studio.
Yeah.
Publishing states 72. I published image number 1 in state 72. Mr. Gillespie, you see that photo on the screen in front of you?
Mm-hmm. Yes.
Okay. And who's that person?
That's my knowledge, man.
Okay. And the person I'm referring to, what is he wearing?
A jacket.
All right. Do you recognize the person on the other side of the photograph wearing what appears to be a black shirt?
Absolutely.
If you do.
No, I don't.
Okay. Publishing image number 2. Do you recognize the individuals in that photograph?
2 or 3 of them, yeah.
Okay, so what you can do is identify them by the clothing that they're wearing.
Jewelry, black jacket in the left, sack in the middle, jean jacket, tape, black jacket.
And Sack is he standing or sitting?
See,
And Tay, is he standing or sitting?
see.
And you said Portland was wearing a black jacket. Is he standing or sitting?
Who?
Oh, how did you refer to him? My apologies.
Tape.
No,
Or Julie.
the person wearing the black jacket, who did you identify that
Julie
as?
wearing black jacket. Also, is Tate wearing black jacket.
The person wearing the black jacket who's standing up, do you recognize that individual?
Chris.
Okay. Do you recognize the people in photograph image 3?
Same one you just showed. Same person.
And who's that person?
Yeah.
The 3 images that were just shown from state 72, do you recall when those photographs were taken?
Same night.
Would that be, what date would that be?
10/26.
Of 2018?
Yeah.
What location were those photographs taken in?
New Era Promotions Studio.
Was that the studio we just discussed that you guys were hanging out at?
Yeah.
I'm now publishing state 7. Publishing 10/26/2018, beginning at timestamp 2/17/42. Mr. Glass, you recognize the 2 individuals in this screen pause at 2/17/47.
I recognize the back of the head.
Yes, you recognize them.
I just see it back of the head.
Okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52?
Still back of the head.
Do you see an individual standing next to a red vehicle?
Yeah, that's cool.
Okay, you just said that's who?
Cool.
All right. And what is Kobe's real name?
That's what I know about Kobe.
All right. Would anything refresh your recollection as to his legal name?
I don't know.
If I were to show you your prior statement, would that refresh your recollection?
Good.
Permission to approach the witness?
Right.
Mr. Glass, if you could take a moment and look at this page, read it to yourself, do not read aloud, and look up when you're done. Has your memory been refreshed as to the legal name of Kobe?
Yes.
And what is Kobe's legal name?
Objection.
What's the objection?
Sorry, I was.
Kobe Mills.
I'm sorry.
Kobe.
And if you could repeat the last name for the court for additional.
Yes.
All right, I'm going to continue to publish date 7. There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual?
Not really, no.
Okay. How about the individual that is standing at the gray Jeep?
That's sad.
Okay. I'm going to continue to publish. I'm pausing at timestamp 2/18/21. Do you see that individual who's walking away from the Mitsubishi Jeep?
I see him, yeah.
Do you recognize him?
That's AD.
Okay. And again, I'm going to ask you for AD's legal name.
I know his last name, Davis.
Okay. Would looking at your statement refresh your recollection as to his legal name?
I guess so.
Honor, permission to approach?
You have your same statement?
Yes, Judge. Approaching the witness. Mr. Glass, same procedure. You can take a look at that and look up.
We already know the name, guys won't be the same.
Without speaking, has your memory been refreshed as to AD's legal name?
Yes.
Okay, what is AD's legal name?
Adrian Davis.
Continuing to publish, date 7. Mr. Glass, let me know if I need to rewind the video, but you had a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts.
It's me.
Okay. Continuing to publish. I'm pausing the video at 2:18:41. You see that individual wearing something across his shoulder, wearing what appears to be a blue jacket. Do you see that person on the video? Do you see the back of the head of the person wearing the jeans jacket? Was that person the same person that you previously identified?
Stay, rephrase it.
Okay. We previously looked in state 72 at an individual you identified as Melly.
Stay.
One moment. Publishing state 72.
Asked and answered, Your Honor.
There's no question pending.
Okay. Do you see the jacket in states 72, image number 3, the front of that jacket?
Yeah.
You see that jacket in states image 1 of state 72.
I see the same thing y'all see.
We spoke about this, Mr. Glass.
I'm saying that.
You ask questions.
I'm asking questions, Mr. Glass, and I'm just asking you to respond if you have knowledge. Is that jacket that was in image number 1 and image number 3 the jacket that Melly was wearing on October 26th of 2018?
That's my knowledge.
To the best of your knowledge, yes or no?
Yes.
Publishing state 7. And then go. Okay. Back to state 7, timestamp 2:18:41. The individual that's on screen wearing a jacket and it appears to be something across his back. Who is that individual?
Objection, passed and answered.
Overruled.
Mr. Glass, you can respond.
I see the same person as last time.
Okay, and can you tell us who that same person is?
Yep.
Continuing to publish.
That's a question John really answers to.
Mr. Glass, you can't speak when there's not a question. Mr. Glass, you see that individual carrying something in their left hand. I'm asking if you see them, just if you see them. Do you recognize that person? Okay, and who is that person?
Thomas.
Mr. Glass, can you identify for the record, and I know there's a video, but can you identify which vehicle you got into?
Rams.
And can you tell us who was in that car with you?
Kobe, Tate, and 80.
So 80, Tay, and Cody.
Mhm.
Is that a yes?
Yes,
So that is a total of 4 people.
correct.
And in the vehicle to the left of the screen, the Jeep, who entered that vehicle to your knowledge?
Everybody else that was there. Zach, Melly, Julie, Court.
And by my count, is that also 4 people?
Correct.
Right? And when those, okay. Continue to publish. At 2:19:36. I'm gonna stop at 2:19:46. At the time you left the studio in that red Mitsubishi, where were you headed?
Supposed to be home.
Okay, and who's home?
It's Melly's house.
Okay, and was everybody in that red car headed to Melly's house?
To the best of my knowledge.
Okay, and what about the Jeep? Where was your understanding that that Jeep was headed? The gray Jeep?
Same spot.
Okay. So both cars left the studio with the intention of heading to what you identify as Melly's house?
Correct.
Can you tell us, I guess, what was the mood or the vibe at the studio while you guys were there?
5 years ago. Can't tell you nothing right now.
Okay, if you don't recall, that's fine. Was there any physical confrontation that you observed at the studio?
Just like a regular day. Studio, smoking, drink.
Right. And you just mentioned smoking. What were you smoking, specifically you?
Weed.
Okay. All right, and now the vehicles, we saw that the gray vehicle on the video pulled off first. Can you tell us where you guys, the route you guys took to the best of your knowledge?
I can't tell you because I don't know.
Okay. Do you recall getting on a highway at all?
I recall being in the car while I was driving. I don't know where. I don't.
Okay. Were you awake the entire time you were in that vehicle?
I wasn't.
Okay. Do you know at what point you fell asleep?
I don't.
All right. And when you left the studio, you were awake. Is that a fair statement?
I was.
And at what point do you recall waking up, or what time do you recall the next thing you saw?
Once we came to a stop.
All right. And where did you come to a stop?
At the house gate.
And the house gate for Melly's house.
Yeah.
When you got to the house gate at Melly's house, who was inside your vehicle, the red Mitsubishi?
Same people you've seen get in the car.
All right. So by your testimony, Kobe, AD, Tate, and yourself.
Yes.
Okay. So still 4 people.
Still 4 people.
Do you recall how you guys entered the gate?
The gate was open for us.
Okay. And publishing states 47. I'm gonna pause it at timestamp 3:49, looks like 58. Do you recognize that red Jeep? Mitsubishi?
I do.
Is that the vehicle that you left the studio in?
Yes.
And is this the guard gate you just testified to at Melly's house?
Yes.
Okay, and do you see that screenshot at timestamp 3:51:31?
Mm-hmm.
Is that a yes?
Yes.
Okay, do you see yourself inside that red Mitsubishi vehicle?
Yes.
And where are you located? Okay, and do you recall going through the procedure of going through the gate?
Yes.
So you get through the gate, where do you go next?
The house.
All right, and can you tell us, you pull into the house, is there driveway in the house, in front of the house?
Yeah.
Okay, are there any other cars parked in that driveway when you get to the house?
No.
All right, do you see the gray Jeep that you left the studio with at the house?
No.
All right, so what do you do when you get out of the vehicle?
From what I remember, I went upstairs and went to sleep.
Okay, and you said upstairs, so the house is how many stories?
Couple.
Okay, so you went upstairs to where specifically to sleep,
In Julie's room.
right? Was Juby in his room?
Nah.
Okay. Do you recall where Melly's room was in the house?
Not upstairs.
Okay. Do you recall where it was if it was not upstairs?
I think it was like first room as soon as you come in the house.
Okay. Was Melly at the house when you got there, from what you can recall?
No.
Did you see Melly at any time in the house?
No.
right? So you go upstairs in Judy's room, and what do you do?
Crash.
All right, crash meaning,
Go sleep.
okay. At some point, do you wake up,
Yeah.
and why?
Phone
How?
calls, phone calls, phone calls, phone calls.
Okay, safe to say that your phone was getting a lot of phone calls, blowing up.
Yeah.
All right, and at some point, you answer the phone, correct?
Yeah.
Okay, what do you do in response to the phone calls?
I answered the one that kept ringing, and yeah,
All right, and so what do you do in response to getting that phone call?
I ended up at hospital.
All right, do you recall which hospital that was?
No, I don't.
Do you recall what city you were in at this point?
I was just in Broward.
All right, what city, not the county?
Miramar.
Okay, do you know if you went to Miramar Hospital?
I don't know what hospital it was.
Okay, so you get to the hospital, what do you find out when you get to the hospital?
That Anthony and Christopher was deceased.
Okay, and obviously at that, well, let me not say obviously, but at that point in time, what do you do? Or how do you react to that news?
Great.
Okay. Do you stay at the hospital?
Not long.
Okay. Where do you go after the hospital?
I ended up somewhere, somebody's house.
All right. Do you recall whose house that was?
I don't know whose house it was, but I ended up there.
All right. Let's start with the city. Do you recall what city that house was in?
Anyone?
All right. Do you recall if it was in the same or different area than where Melly's house was?
It looked similar.
Okay. And just to clarify, was it the same or different house than Melly's house?
Different.
Okay. Where did you go when you went to that house?
What you mean?
Like, where in the house did you go? So you go to the house, where do you go?
I went inside the house, I was in the back.
Okay. And would your statement reflect your recollection as to whose house you were at?
Maybe.
Can I have permission to approach and show counsel the same statement? Thank you.
Same procedure as the class, if you could just review page 4.
I don't see nothing but a house.
If you could just read the entire page, and when you're done, let me know.
Have you finished reading that page?
Yeah.
Does your memory give you refresh as to whose house you were at?
Still don't see nothing about the house in there.
Okay. I'm gonna now show you what's in evidence. It's page 62. Do you recognize the individuals in page 62?
Yeah. Got it.
Okay. Who are those individuals?
Melly and another dude, Fredo.
Okay. You said Melly and another dude, Frito?
Yeah.
Do you know Frito's name and or any nicknames?
That's all I know about him.
Frito? Do you recall ever going to Frito's house?
Just that time.
And just that time being what time?
After I left the hospital.
Okay. So this. And for the record, what is Frito wearing in the photograph?
Sure. What shirt?
Okay. So after the hospital, you went to Frito's house.
To the best of my knowledge.
Okay. And what were you doing at that house?
Still grieving.
Okay. Who took you to the hospital?
The cameraman.
And do you recall his name?
Drew.
Right. And do you recall who took you from the hospital to Frito's house?
Same person.
All right. And before you left for the hospital, or actually, who went to the hospital with you?
Just Drew.
Okay. Who was at the house, Melly's house, before you left for the hospital?
Same people that only got it.
Okay. And same people being the 4 people that entered the Mitsubishi?
Yes.
Okay. So you're at Frito's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were? Oh, no, not Melly's house. Frito's house. Where were you in Frito's house?
Outside.
Okay. And who was at Frito's house when you first got there?
Everybody that was in the house.
Okay. And it's because I don't know who everybody was or is. Can you please specify?
Kobe, Melly. The only people I can remember.
Okay. Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new day. Nah, he wasn't.
Nah, he wasn't. You guys
Wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
And how long did you stay at Frito Bain's house?
I don't know.
Like minutes, hours, days?
Could be minutes, could be hours.
Okay. So not days.
Not even a day.
Okay. And so when you got to Frito's house, was it light or dark outside?
Just like
And you previously said yourself and Melly and someone else was at Frito's house. Was Frito there as well?
I think I did see him. I don't remember.
Okay. What happens while you're there? Like you're there, you're outside, what happens?
Greeting.
Okay. And you're grieving, are you grieving alone?
Yes.
Are you at the house at any point in time? Do more people come to the house or do people leave the house?
If they did come, I don't know. I was in back.
Okay.
I was back at Free.
At any point in time, did Melly leave Frito's house?
It came to a point when I was there by myself.
All right. So you were there by yourself. So the people that you previously said were there were no longer there, correct?
Right.
And so do you know where they went during that time?
I don't.
All right. And we're still talking about October 26th of 2018, correct?
Yes.
And this would be shortly after the hospital?
Yes.
All right. At some point, does Melly come back to Frito's house?
Around this time, I'm still grieving and getting a little, I don't know. Yeah, I guess.
Yeah, I guess Melly comes back.
Yeah, I guess they did come back.
Right.
I don't know. I'm not sure.
Okay. And at some point, does Melly leave again, a second time?
I don't remember anything farther after that.
All right.
We grieving. That was the last thing I remember is we grieving. Not anything different.
All right. So before you end up in Griffin, if I were to show you a statement, would that refresh your recollection as to Melly leaving and coming back a second time?
I suppose so.
Under permission to show him his statement again?
Yes, ma'am.
Mr. Class, I'm gonna give you page 5 and page 6, if you can take a look. You can start in the middle and review those pages and look up when you're done.
Are you done? Is that a guess?
Yes.
Did that refresh your recollection?
Somewhat.
Okay, so tell us what you somewhat remember.
I just did.
If you recall, you said you weren't sure, you went to Gifford, and then I asked you if your statement would refresh your recollection. Does your statement refresh your recollection as to whether Melly left again?
I'm not sure they left. I was grieving.
Okay.
I'm not sure what nobody did. I was grieving.
All right. You mentioned, well, nothing mentioned, let's see. I pointed out to you someone was, the person that was wearing the jacket that you identified as Melly was carrying something across his side or his back on the video. Do you recall seeing that?
Yes.
Okay. Do you recall what that's referred to?
Essential.
Okay. Can it also be commonly referred to?
Objection.
Sustained.
Are you familiar with the term man?
Objection.
Watch from sideline.
Did you see, that satchel again after you left the studio? You know what was in that satchel?
I don't.
Do you recall seeing anyone else with a satchel that night at the studio?
It's 5 years ago. I don't recall.
Is there anything that can refresh your recollection as to whether or not anybody else was wearing a satchel?
I'm supposed to.
If I were to show you the video again, does that refresh your recollection?
I'm supposed to.
Publishing Suite 7. I'm going to start publishing Suite 7 at 2:19:01. I'm going to pause at 2:19:13. Does the video refresh your recollection as to anyone else that was carrying a satchel?
Yes.
Who, if anyone, was carrying a satchel?
I see Christopher one.
And that's Christopher Thomas.
Yes.
Did you ever have any business relationship with the person I refer to as Track?
No.
Okay. Do you know who Track is?
Not really.
Not really, or
I don't know who he is at all.
do you know of him?
Yeah.
Okay. Did you see Track on October 26, 2018 at any point?
No.
Do you recall getting a statement, specifically the statement that I previously provided you with here today? To the detectives in this case. You have to answer out loud.
Yes.
That was a statement that you gave to Detective Moretti and another detective, I believe from Indian River. Is that correct?
Could be.
Do you recall in that statement giving a different response when asked?
Stay.
Would showing you that statement refresh your recollection as to anything regarding your interactions with Track on October 26, 2018?
I don't know Track.
No, my question was, would showing you the statement refresh your recollection as to any time you saw Track on October 26th of 2018?
No.
Okay. One moment. You said you ended up back in Gifford at some point in time on October 26th of 2018?
Yes.
And do you recall where Melly was at the time you went to Gifford?
I don't remember.
Was at some point at Frito's house, you guys all leave, meaning you, yourself, everyone that you previously identified was there?
Objection. I don't recall.
You don't recall leaving?
I don't recall leaving with anyone. I don't know when I left. I don't know how I left.
Okay. Just to clarify my question, so you mentioned you left. When you left for Gifford, was anyone else at Frito's house?
I don't know.
Do you recall Melly making any statements in your presence while you were at Frito's house?
I don't recall.
Would showing you your statement refresh your recollection as to anything Melly told you while you were there?
I don't recall being told anything, so no.
Okay. You mentioned when they left the first time, you recall them at least leaving one time. Did you recall if when they came back, there were any statements regarding where they went?
Sustained.
No, don't answer that. So you remember them leaving the house at least once, correct?
Yes.
All right. Now, when they came back, do you recall any conversations that Melly had in your presence that first time, after the first time?
I don't recall.
Would show you your statement, refresh your recollection as to those statements.
No, really.
All right. Did you have a Facebook page back in October 26th of 2018?
I believe so.
On approaching council, what's been pre-marked is states quadruple I. Previously shown. Wish to raise witness? Mr. Glass, do you recognize these two pages that I'm showing to you?
Yes, sir.
And is this a Facebook, these statements reflect a Facebook conversation?
They do.
Is this a fair and accurate representation of that conversation that you had on Facebook?
It is.
Right, Your Honor, at this time, the state would move to introduce what's been pre-marked to stage quadruple I is the next number to exhibit.
No objection.
I'm sorry?
No objection, Your Honor.
It'll be admitted.
States quadruple I will be marked states 83.
Permission to publish?
You may.
Mr. Glass, can you see that document in front of you?
Yes.
All right. Where it says author, can you read that for the members of the jury?
You want me to read
If you can read that, what does it say next to author?
Fargo?
What does it say before Fargo?
Okay, Fargo.
Okay, do you see where it says Fetty Fargo?
Let's see.
Okay, and who's Fetty Fargo?
It was me.
Okay, so was that your was that a, how you identified yourself on Facebook?
I'm sorry.
And who were you having this conversation with?
Right now, I look like I'm talking to myself. I
Okay.
look like I'm texting myself. I don't know who I said it to.
Do you see where it says participants?
Okay. So, Jason Melly.
Okay. And that was page 1. I'm gonna now publish page 2. I'll publish it in part, since it's a little small. Can you see that in front of you?
Yes.
Great, I'm gonna scroll up. What was the purpose of you having this conversation with Melly, Jamel Bennett?
I don't know. Just everything is questioned.
When you got to Gifford, were you looking for answers?
Not just me.
Okay. Were people kind of pressing you for answers?
Correct.
And did that have any impact in whether or not you reached out to Melly?
I don't know what you mean by that.
So, and again, you said that people were looking for answers. So did you reach out to Melly looking for answers?
I did.
Is that the gist of that conversation on Facebook?
Is that just a
The
conversation?
gist of the conversation, was that the purpose behind the conversation and the general conversation that you had with him?
Yes.
Ryan, I want to confer. Do you know who Jamie King is?
I don't know who she is. I know of.
Okay, you know of Jamie King. Do you know how she's related to Jamel Demons?
Objection leading.
Sustained.
Do you know her relationship?
Mom. So his mom.
Okay. Do you know if Jamie King and Anthony Williams had any?
Objection leading.
I wouldn't know none of that.
Rephrase your question.
Do you know the relationship between Jamie King and Anthony Williams?
I don't.
If I were to show you a copy of your statement, would that refresh your recollection?
No.
And one moment, further. Nothing further at this time.
Counsel, thank you. Is there any cross-examination this week?
Yes, sir.
All right, Taylor gang. So real quick, I need to run to the bank real quick. So we could pause right here so I can run over to the bank and I can come back, or we can end for the day. What y'all want to do? Because I got time, but I gotta go to the bank. So do y'all want to we can pause, take a quick break. It's probably gonna take me like 20 minutes, 20, 30 minutes to run to the bank. And come back, or we could just pick back up on what's today? Tuesday or Thursday. Beta says pause. Get me some money too, child. You gotta have some. You cannot. The new year cannot come in if you don't got no dollars in your pocket. You need some dollars in your pocket. You cannot. Okay. All right. So the consensus is that we'll pause. So we'll just take a break. Quick break. And we will be back. Yeah, you gotta have some money in your pocket. So I encourage you right now. I don't care if it's a $1 bill, a $5 bill, a $10 bill, a $20 bill. Do not let 12 o'clock hit and you don't have no money in your pocket. Okay. Just one of those things that we have to do. So we'll take a quick break. I'll be right back. I'm making like the little thing, and we'll pick back up on cross-examination. All right, I'll be right back, guys.
Good morning. Good morning, Mr. Glass. Your Honor, would you mind if we move the monitor from in front of the witness's face?
I don't mind. I mean, I mind.
Would you mind, Your Honor?
I don't mind. Is there a specific issue that you have, Mr.
I do. I do.
Judge,
So,
can we approach sidebar?
sure. Ladies and gentlemen, why don't you step out for a second? Don't discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in the presence of no reason. The jury said that Dr. Manuel was defendant and assistant state attorneys. So, Mr. Glass, I don't understand. What's the issue?
I don't know this on my face until when it was seen. So I'm blind in my left eye, I'm trying not to.
So you don't see out your left side,
Correct.
left eye?
Correct.
So my thought is, let's try this. Can we, Gary, can you do me a favor? Just move the monitor for a second?
Yes, move it out of the way.
Can you do that?
I can do that too. But if I do, as far as this goes.
No,
Attached.
I'm not asking you to attach it. How much do you put it down?
That's, just here.
All right. So, Mr. Glass, is that all right?
Sure, Glass.
Okay. So we can proceed like that. I think that works for everybody. So they show you pictures and things like that. You have to be able to see the monitor too. You understand, Mr. Glass? All right. We ready to proceed? Yes. All right. Bring the jury back and see if they're ready. All right, we'll be in recess. Mr. Dennis, you need a rest for no? We're in recess.
And do you recall who took you from the hospital to Freedom's house?
Same person.
All right. And before you left for the hospital, or actually, who went to the hospital with you?
Just true.
Okay. Who was at the house, Melly's house, before you left for the hospital?
Same people that was there when we got there.
Okay. And same people being the 4 people that entered the Mitsubishi?
Yes.
Okay. So you're at Frito's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were?
Julie's room.
Oh, no, not Melly's house. Frito's house. Where were you in Frito's house?
Outside.
Okay. And who was at Frito's house when you first got there?
Everybody that was in the house.
Okay. And it's because I don't know who everybody was or is. Can you please specify?
Kobe, Melly. I'm gonna people I can remember.
Okay. Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new day. Nah, he wasn't.
Nah, he wasn't. You guys
Wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
Okay. And how long did you stay at Frito Bain's house?
I don't know.
All right. Minutes, hours, days?
Could be minutes, could be hours.
Okay. So not days.
Not even a day.
Okay. And so when you got to Frito's house, was it light or dark outside?
Just like
And you previously said yourself and Melly and someone else was at Rio's house. Was Rio there as well?
I think I did see him. I don't remember.
Okay. What happens while you're there? Like you're there, you're outside, what happens?
Greeting.
Okay. And you're grieving, are you grieving alone?
Yes.
Are you at the house, at any point in time, do more people come to the house or do people leave the house?
If they did come, I don't know. I was just back.
Okay.
I was back at the free.
At any point in time, did Melly leave Rio's house?
It came.
Okay, so Janine, now you're hearing how he found out that they were both killed. He was grieving, talking about where he was at. What are you taking away from this?
And he's also talking about how Melly wasn't wearing the same clothes, which kind of seems odd to me because, I think that once you hear that your friend's been shot, he goes over to the hospital with, I forget what guy took him, and you would think that Melly would not be changing his clothes and stuff, but I thought that was interesting. I think it's a really cumbersome testimony, though. He really is uncooperative, and he really kind of gives these really one-word answers. He's annoyed, and I really think that, it's hard testimony to get through.
Well, let's actually take a break, and I'm curious to see if he says he had any other interactions with YNW Melly or Cortland Henry after this took place. So stay with us, and we'll see more of his testimony on the other side.
So the record is clear. It appears that Mr. Glass was reading something from his phone and as Your Honor walked in, talking to someone on the phone. So I would ask the court to inquire as to what he's reading and who he's speaking to while he's on the witness stand.
So the only individual who's not allowed to speak with me, myself and Ms. Smith, so I think that should be extended to the inquiry.
Thank you. Mr. Glass? You're looking at me. All right, thank you. I wasn't here. I left the office, left the bench time. We're in recess, came back in, and counsel suggested to me that you're on the phone and you read something and you're discussing something on the phone. Is that true?
Sure.
Yes, so did it have anything to do with this case? So was some other business or?
Texting.
You were texting? Were you texting about the case?
I don't know it.
What were you texting?
Texting saying that this wild shit wild. That's all I said.
I didn't hear you.
I said things are wild. That's all I said.
Things are wild.
It's wild.
Anything else?
That's it.
And did you have a conversation with someone?
But called me and was concerned. That's all.
Concerned?
Yeah.
Concerned about what? Did you say?
Concerned about who I'm here with and how I got here.
Okay. And anything about the case, facts of the case, your testimony, anything like that? Thank you. All right, so are you ready to proceed?
Yes, sir.
Stay ready to proceed?
Yes, sir.
All right, can we proceed? The jury's ready?
Yes, sir.
Jury entry?
Thank you very much.
gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, the defendant's counsel, and assistant attorneys. And during the jury, all witness, Mr. Glass remains on stand. Counsel, this is your opportunity for cross-examination. If you're ready, you may proceed.
Thank you, Your Honor. Morning, Mr. Glass. Morning, sir. I wanted to show you what the state admitted as States 83. You just took a peek at this and identified the participants as being you. You thought it looked like you were talking to yourself because you were the only one typing. There were no responses, at least on the first page, correct?
Objection to public testimony.
Sustained.
There are no responses to this. To your text on this first page.
No.
On the second page, the state was discussing that essentially you were inquiring of Mr. Demons Melly what had gone on because you were trying to get information, right?
Yeah.
And you see a conversation here where you get a response. I'm gonna direct your attention to that statement. It says, I show them niggas more love than their parents, right? You see that?
I see it, bro.
Okay, thank you. And the next statement by the next message in sequence is again from Melly, and it says TF. What does that mean?
Chilling.
Okay. What does that mean?
I don't know.
Okay. So you were having a conversation and you didn't understand the
I don't know what
response.
TF means.
Okay. You didn't understand that response. Correct?
Just said it.
Okay. And then there's another one that says, man, tell them fuck that. If they think I did some shit like that, we can go to war. Nigga, you know I would never do nothing like that. See that?
That's it.
Okay. So State mentioned that you got arrested recently and charged criminally. Correct?
Correct.
And on May 30th, not too long ago, of this year.
Yeah.
And one of the charges that was made against you was obstruction of the service of the execution of the search warrant. You're aware of that?
I am not.
Pardon me?
I am not.
Okay. So you got charged and you had no idea what you're charged with?
Correct.
Okay. And you are now out of pretrial release?
I'm bonded out, sir.
Okay. And while you are on bond, you are of the opinion that if you don't come here,
I'll be in jail.
Objection on voting.
That's the only reason I am.
Excuse me. What happens is when they make an objection, just wait before you answer. Objection, no, it's overruled. Proceed.
That's
you're of the impression that if you don't come here and sit in that chair and testify, you're gonna go to jail.
correct.
Okay. There are several instances in which Ms. Smith, prosecutor, that questioned you, showed you a statement that she previously gave. Remember that?
Yes.
And you told us, you remember seeing me in a deposition not too long.
I said what?
You remember seeing me last week on Friday.
Yeah, I remember.
And you recall at the time that your statement to the detectives was a few days after the incident.
You say, do I recall?
That's what your recollection was at the time.
Yes.
A couple of days after.
A couple of days after.
And now after seeing the statement, you realize that it was 4 months later, right?
You say what?
The statement you gave to police. That's
You're telling me it was 4 months?
It was 4 months later. Pardon me?
You're telling me or asking me?
I'm asking.
That don't make sense. For you to ask me if I told you it was 3 to 4 days after they died, why are you asking me if it was 4 months if I just told you?
Okay. So, in the statement that you gave to police back then, you claimed that you had gotten into the red vehicle in the rear seat, right?
5 years ago. To the best of my knowledge, yeah, that's what I said.
You're saying the statement was a few days after, right?
What did you tweet?
The statement that you gave to the police was a few days after the incident?
Yes.
And you said then that you had gotten into the rear of the red vehicle.
To the best of my knowledge, yes.
Okay. And then you watched this trial unfold on TV over the last couple of weeks, right?
No.
You didn't watch any of this
I
trial?
watched it, but I didn't watch it unfold, whatever you're trying to say.
Okay. You watched this on TV, this trial?
On my phone.
Okay. And you saw a video of yourself get into the red vehicle, right?
Correct.
And you learned that the statement that you gave a few days after the incident was wrong?
Because I said I was in the back and I was in front.
Yes, exactly that.
That piece.
Yes, that piece.
Yeah, okay, yeah.
Okay, so your recollection had begun to fail you only a few days after the incident
Objection.
as regards that issue, at least.
Objection to counsel testifying as Patrick.
You forgot where you sat in the vehicle a few days after.
Objection to counsel testifying.
Overruled.
You can answer
Answer what?
that question. Is that correct,
Did
sir?
I forget?
Did you
Or
forget?
did I have made a mistake and say I was in the back and remember that I was in the front?
So when you told the law enforcement officers that you had gotten into the back of the vehicle a few days after the incident,
That's what I thought, to the best of my knowledge.
that's what you thought, okay. And when you got to Melly's house that morning, you had a key?
Did you have a key?
No, I didn't. Did you?
No, I didn't.
Who had a key?
I don't know.
You know of anybody having a key to Melly's house?
I don't know.
Okay. But you did gain entrance to that house that morning when you were leaving after you left the studio.
Yeah.
Okay. And then you said you just went and crashed and went to sleep in Judy's room. Right?
Factual.
Okay. And you were awakened by your friend Drew.
I did not say that.
Were you awakened by your friend Drew?
I said I was waiting on my phone calls.
Okay. On February 26th of 2019, when you actually gave your statement to law enforcement, do you recall this question and this answer?
Objection to improper impeachment.
Sustained.
On that day, you told the police that Drew woke you up.
Objection to improper impeachment.
Sustained.
I don't recall.
Excuse me, sustain the objection.
Okay. On, you're on the reproach?
Sure.
Did you ever make a statement differently where you claimed that you were awakened by Drew?
Objection, counsel testifying improper impeachment.
Overruled. Do you understand the question, sir?
I don't even remember getting asked a question.
All right, restate the question.
Did you ever make a statement to the police
I don't recall.
Do you recall now being asked this question and giving this answer?
Objection to improper impeachment.
Overruled.
Question by Detective Ben. And so when you first saw Drew, when did you see him? Where did you see him at? Your house or Fredo's house? Answer, at the house in Miramar. At Melly's house. Okay. He woke me up. It was like, come to the hospital. You said that.
I don't recall.
Don't recall, okay. When we spoke to you last week, you said you were awakened by phone calls from Christopher Thomas's mom, right?
Plenty of phone calls.
And, pardon me?
Different people.
Different people. And the one that you answered was Ricky? So you were awakened by a phone call from Ricky?
To the best of my knowledge.
So as you recall it today, Ricky is the one that woke you up with phone calls, not Drew that woke you up in person.
Correct.
Okay. So you smoke a lot of marijuana, right?
Possibly.
Well, you smoke it anytime you get a chance, I think is how you phrase it.
It's your answer. Yeah.
That was your answer.
I smoke when I smoke.
You smoke when you smoke?
Yeah.
And when's that?
When I smoke.
And when was that?
When I smoke.
How many times a day?
Objection to ask and answer.
Overruled.
Twice, 3 times, maybe.
Okay. And on the night before you got to the studio, on the day in question, you had smoked at least 2 joints, right?
Sure, yes.
That's what you said, right?
I don't recall.
Okay. And when you got to the studio, you were smoking, correct?
Possibly.
Were you or weren't you?
It was 5 years ago.
You forget?
I don't recall.
Okay. And you were drinking Hennessy, I believe? Or do you not recall that either?
It's possible.
Possible. But you don't recall?
I don't.
Okay. So you don't recall much from that night, do you? Right? Fair?
Right.
Okay. And when you got in the red vehicle and left, you went to sleep in the vehicle when you left the studio. Right?
Yeah.
And you didn't wake up until you got to the guard gate.
I woke up when we came to a stop.
You did not wake up until you got to the guard gate. Am I right or wrong?
I woke up when we came to a stop.
Okay,
Which was at the guard gate, yes.
Okay. One moment. With respect to your daily, right? You never seen Melly with a gun.
Objection, Your Honor.
Same.
Move to strike.
Here's this for our last question.
Have you ever seen Melly with a gun?
Objection, Your Honor.
Sustained objection.
Have you ever seen him track with a gun?
Possibly. Yes. Maybe. Maybe so.
You don't know of any friction between Melly and Anthony Davis at any time, Anthony Williams at any time.
I know.
And you don't know of any friction between Melly and Christopher Thomas at any time.
I know.
And you don't know of any friction that occurred at the studio that night that would cause anybody to get hurt.
Objection, Your Honor. False speculation.
Sustained.
You didn't see any friction at the studio that night of any magnitude?
I did.
You did?
I didn't.
Okay, you did. With respect to your daily marijuana regimen, did you smoke before you came here today?
I did not.
I have nothing. Thank you.
I should
Counsel, is there any regret?
One moment, Your Honor. Mr. Blas, did you live in Broward County back in October of 2018?
I did not live here.
Okay. When did you come in relation to this incident to Broward County?
I was picked up probably, I don't know, I was picked up on the weekend or something like that.
So how would you, I guess, date how long you were here prior to the incident? Time frame.
3 days, 2 days.
Okay. So you were not a full-time resident of Melly's residence?
Was not.
Nothing further.
Is this witness excused?
Yes, Your Honor.
Thank you, sir. You may sit down. You are excused. It's 12 o'clock, so ladies and gentlemen, I'll take our lunch and recess now. It's like so after 12. And remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in presence. And certainly no research. We'll see everybody back at, let's say 1:30. All right? Thank you, ladies and gentlemen. Keep on heading, cheers. Thank you, let the record reflect the jury step down, counsel Randall, with the defendant, anything to discuss, counsel? Thank you,
Do you see where it says participants?
Okay. So checks and Melly.
Okay. And that was page 1. I'm going to now publish page 2. I'll publish it in part. It's a little small. Can you see that in front of you?
Mm-hmm. Yes.
Great. I'm going to scroll up. What was the purpose of you having this conversation with Melly? Jamal?
I don't know. Just everything's question.
When you got to Gifford, were you looking for answers?
Not just me.
Okay. Were people kind of pressing you for answers?
Correct.
And did that have any impact in whether or not you reached out to Melly?
I don't know what you mean by it.
So, and again, you said that people were looking for answers. So did you reach out to Melly looking for answers?
I did.
Is that the gist of that conversation on Facebook?
Is that just
The gist of the conversation, was that the purpose behind the conversation and the general conversation that you had with him?
Yes.
Random to confer. Do you know who Jamie King is?
I don't know who she is. I know of.
Okay, you know of Jamie King. Do you know how she's related to Janelle Demons?
She's leading.
Sustain.
Do you know her relationship?
Mom. So his mom.
Okay. Do you know if Jamie King and Anthony Williams had any?
Objection leading. I wouldn't know none of that.
Rephrase your question.
Do you know the relationship between Jamie King and Anthony Williams?
I don't.
If I were to show you a copy of your statement, would that refresh your recollection?
Nope.
And one moment, sir.
Well, no, that was not a Dell computer screen that was testifying. That was a very important witness, Travion Glass. He left with everyone that night from the recording studio. He was in the red Mitsubishi. He's a very smart witness. The prosecution, as you can tell, is having a lot of problems. When he was asked whether or not he remembered anything, he said he didn't. When he was asked whether or not his statement would refresh his recollection, he said it won't, which means the prosecutor couldn't present it to him. So on the other side of here, though, we are going to have some much more important discussion of this with our own Anjanette Levy, who will be hosting an hour question and answer, if not more, while the jury is at lunch. Stay tuned. All your questions, submit them to Law and Crime, and we'll be back after this break.
I don't know why we have,
or sorry, 25 videos, we're down to 24, just showing who is using the phone and operation on the phone.
I don't know the relevancy of that, and it's repetitious to the 525 photos that we went through in about 3 hours the other day, coming from reportedly his phone. I don't know why we have to go through all of this again. And there's also a short video of a little baby on that also. I don't know what the relevancy of any of this is. And if it is relevant, if she can't get it through the 525 pictures that we have to sift through, where she manually counted each one, I don't know what we're doing, Judge, quite honestly. So I would object on relevancy. Cheese with it. These are fancy words.
Yes, sir, the state has to prove that the defendant was the one using the 772-713-9807 phone number. This is a short selection that is representative of the number of videos that are on there that show the defendant being the person using the phone. The defense has argued that it's not his own in any way, shape, or form. So this is showing that there is no one else on there, and that even the photos and videos that show other people, for example, have the defendant using the cell phone to FaceTime and videotape a FaceTime of another individual. And constantly showing the phone in the defendant's hands, sometimes reflected in some sunglasses or eyeglasses on screen.
I know counsel objected to on relevance grounds. I already breached that, and we crossed that bridge a while ago. I overruled that objection. But now there's another objection to cumulative. Haven't we seen these videos and pictures?
We have. These are different ones from different time frames, showing that the defendant had exclusive control of this phone for all times relevant to this case.
There's one where there's a child on it. I think it violates the children's, what is it?
Online Privacy Protection Act, which says children under the age of 13 cannot be filmed or published without the parents' consent. One of those videos is a video of
A little kid. John,
what's that video about?
It shows the defendant's voice in the video. It then has him filming a FaceTime of another individual. Apparently, the state didn't create these videos, the defendant did, so if anything, he's the one who would be in violation of that particular act.
I disagree with that.
I don't know what the act says, but what is this statute say?
I'm not familiar with the first time that this has brought my attention.
COVID imposes certain requirements on operators of websites or online services directed to children under 13. Long and short of it is basically you cannot record or publish children under the age of 13 without their parents' permission.
What's the statute number?
It would be 16 CFR Part 312, Children's Online Privacy Protection Act.
16 CFR 12?
Part 312.
312. So how many of these videos do you have?
There are 24 now, Your Honor, out of 1,000.
All right, and you want to show this one with the child as well?
Yes, Your Honor, shows the defendant holding the phone and videoing.
You can show some of these other videos first. All right?
Yes, Your Honor. Do you want to see the one in question?
No, I want to see what this statute says, 16 CFR 312.
Your Honor, there's an additional individual. First of all, I just wanted to crystallize our position that if they're putting in 530 photos to establish that it's his phone, adding another 20-something videos doesn't move the ball. It's cumulative and should be excluded. We object on those grounds. There's also video number 1, 2, 3, 4. And in that video, Mr. Demons uses a pejorative term that I don't want, that I think will be inflammatory, and on 403 grounds we would object. It refers to Caucasians as crackers, and I don't want any of the jurors who might be of that race to form a negative impression and be prejudiced in their assessment for the sake of proving that Mr. Demons owned a phone that they've already seen 530 photos from.
But with regards to that last video that counsel is taking issue with, this is the absolute last video or audio file that is on this phone before the defendant turns himself in. And he does use that term, however, I think in the totality of the circumstances, it is more probative than prejudicial.
We stipulate that you use the phone on that day.
My name is Melly, and I'm gonna turn myself in, but I'm in a suitcase because these private are arresting me, and I have to get on a private jet. I don't want them to see me.
So in terms of, it shows the defendant just prior to his arrest and booking, and showing that he was turning himself in, which has already been testimony about, that was brought in from the defense with regards to Deputy Nacop, who did the booking prints in this case.
We'll stipulate that he used the phone on that day to avoid the potential prejudice of him offending jurors on the racial majority.
Play it again.
Sure.
Can you see it? His dream place. My name is Melly, and I'm gonna turn myself in, but I'm in a suitcase because these privates are arresting me, and I have to get on a private jet. I don't want them to see me.
And so, just to be clear, there has been numerous other inflammatory, racially motivated terminology and language that has been used, and there's been no objection on that front.
Bill, done anything else?
Nothing else.
All right, so regarding the one with the presumably under 13-year-old child on the video, just hold that until I can see what the CFR say. To the jury regarding the last video where the majority of terms used, crafters, just go ahead and delete it. All right.
So the kind of permission is I can take out just that term?
Yep.
Okay.
That's what we
I'll need a couple minutes to do that.
I hope that didn't look like that.
Welcome back to the Law and Crime Network. I'm Linda Kenny.
I have to get on a private jet. I don't want them to see me.
You ready to go?
Yes, Ryan?
All right, let's get back on the record as State Florida versus Denver. Present is the defendant, his counsel, the assistant state attorneys, juries and a jury. Regarding the objection was posted about the child on the CFR. That objection noted. I looked at the CFR question. I don't think it's applicable. The objection notes over here. All right, and you took out the word term cracker.
I did, Your Honor, and I played it for Mr. Howard twice, so you can verify that it is silent during that portion.
Thank you. Spring jury.
We can have the technology take the stand.
Sure. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our jury, as well as the defendant, Mr. Devins, his counsel, the assistant state attorneys. And Mr. Riley, this is your next witness.
Yes, Detective Mark Moran.
Mr. Moretti, can you raise your right hand for us?
You solemnly swear or affirm that testimony you give in this case will be the truth, the whole truth, and nothing but the truth.
I do.
You state your full legal name for the record.
Mark Moran.
Spell your first and last name for the court report.
Please have a seat. That microphone in front of you only up or down, it doesn't move back and forth, all right?
Yes, Your Honor.
You ready to proceed?
Yes, Your Honor.
Counsel, you may.
Thank you. Good afternoon, Detective. How are you today?
Well, ma'am, thank you.
Where do you work?
City of Miramar,
How long have you worked for the city of Miramar?
20 years.
And what is your current assignment with the city of Miramar?
Homicide unit.
How long have you been in the homicide unit?
Since 2000, I started working in homicide cases in 2016.
Prior to becoming a homicide detective for the city of Miramar, what other hats did you wear?
I also worked in economic crimes for a couple of years. Before economic crimes, I worked in street crimes, which is street level narcotics, gangs, robbery, violent offenders. Before that, I worked in traffic unit as well as traffic homicide. And then before that, I was in road patrol.
Prior to your time in the Miramar Police Department, did you work for any other law enforcement agency?
Yes, I worked for Pinecrest Police Department in Miami from 1998 to 2003.
And don't make me do math, 2003 to the current, you've been with Miramar?
Yes, ma'am.
Prior to Pinecrest, did you serve in the military or any of the armed forces?
Yes, ma'am. I did a total of 20 years in the military. I did 7 years active in the Air Force, got out shortly after 9/11, went into the Coast Guard Reserve, did another 13 for a total 20 years. I served in enlisted as well as in the officer corps for the Coast Guard.
So in terms of your training experience as a police officer and a detective, did you attend a police academy?
Yes, in 1997, I was still on active duty in the military. I went to St. Petersburg Criminal Justice Center.
And approximately how long was that police academy training?
A couple months.
After you became an officer with Pinecrest, did you have on-the-job training?
Yes, ma'am.
And at Pinecrest PD, did you hold any special titles or roles?
I was a drug recognition expert for field sobriety, impaired drivers. Also, maintained the maintenance on the intoxilizer for courtroom purposes.
In terms of homicide specifically, you're training in just that area?
In Pinecrest,
And all your time in law enforcement?
I've had about 240 hours in homicide investigations. The first class was death investigations here in Broward County. The second one was the Miami-Dade Police Department's Homicide School. And then the third one is through IPTM, which is Institute of Police Technology and Management, which is another 40 hours of formalized training in the area of homicide investigations. And I attended 3 conferences, which each one's 40 hours long, and specifically 2 homicide investigations for about 240 hours just in specialized training.
In terms of on-the-job training, do you have practical experience handling homicide cases?
Yes, I started slowly working homicide cases in 2015, just as training. I was basically writing warrants for the unit. I was doing fraud, and so when they were on scene, they get the station room, and I would get a phone call to start authoring warrants to be prepared for the judge.
Okay, in terms of the number of homicide cases you've handled since you said 2016 is when you went to that
Yes,
unit?
ma'am.
How many homicide cases, or death investigations, I should say, have you handled since then?
Homicide cases I've been involved in about 40 to this point. As the lead, maybe 12, 15. Total death investigations, probably another 20 or 30.
So I want to talk about cell phones. Is that another area you have training experience in?
Yes, ma'am.
What classes have you taken in from Celebrate?
I've been through the basic Celebrate examiner's course to conduct a digital forensic examination of the cell phone, and then interpreting the data from the cell phone as well.
Okay, and in terms of the number of cases that you've worked, give you an approximate number that involves the data from a cell phone itself.
I've probably handled, over the years, probably 75 to 100 cases, specifically just with cell phones.
What about cell phone company data? The true call, the per call measurement, all that.
I've been dealing with that since I came into the Detective Bureau. So that would be in 2013. I've had a bunch of specialized training in regards to cell sites. Been to a forensic mapping course. I've been through with the platform that we use to analyze the cell site data, which is called CellHawk, which is a different platform. Then I've been to the FBI's course, which is the CAST. And I still use CAST, the CAST platform, but for different aspects of cell site analysis. And I've been through an actual specific course for cell phone investigations, just using the phone in your investigations.
Can you explain to ladies and gentlemen what is CellHawk? That's the first time you've heard this term.
CellHawk is the same. It's very similar to what the FBI uses. FBI uses what's called CAST-BIS. CellHawk is just a mapping program working off of Google Maps, to which we plot the data for the cell phone. It takes a lot of the work out. In the past, when we first started to analyzing cell data, we would have to actually plot the towers ourselves, determine what sector, draw the azimuth. Nowadays, we can just take the cell records and put it into CellHawk. We still have to authenticate it, make sure that the data is being read properly, and then we're able to make our determination or apply the data to our case.
So you mentioned plotting and things like that. Do you use mapping software in your day-to-day work as a detective?
Of course, I mean, we just regular Google Maps, Google Earth, it's also a method of open source investigations, is using the mapping.
So I'm going to go to October 26th of 2018. Did you have an occasion to become involved in a Miramar Police Department investigation under Miramar case number 18-10-06269?
Yes, ma'am.
What was your role?
I was called out around about 6 o'clock in the morning. Detective Bertrand called me. I was off, was not working. Hector was in his final year and a half of employment, and he didn't want to take on any new cases. He asked me, he said, I have him at the hospital. I have 2 dead bodies. Would you mind coming out? Of course, I said, yes, ma'am.
So when you got to the hospital, what did you see?
When I first got on scene, I made contact with the on-scene supervisor, which was Sergeant Bermudez, and he walked me through the scene, which was, at that point, it was just a 2018 Jeep Compass that was parked in the emergency unloading zone. It had many bullet holes on it.
Time out for just a second. Can you explain to the ladies and gentlemen of the jury how the emergency room unloading zone is separate and different from other areas of the hospital?
It's a pull up where it has the electric sliding doors that it allows you straight access into the emergency room. Which, all hospitals are relatively standard in that sense that there's going to be a quick immediate access for hospital personnel to provide immediate care in triage type situations.
Is the emergency room the only entrance into that hospital?
No, you can come. There's an entrance off of Pembroke Road, and there's an entrance off of 172.
And when you came to the scene, do you remember which side you went to first?
No, ma'am.
The time when you get to the hospital, you talked about speaking with Sergeant Bermudez. Who else did you see on scene?
Some of the detectives were already there. Detective Bertrand, Detective Toyota was there, and then also a couple of the other sergeants. Because we had 2 young males that were deceased, so it prompted a lot of people to be called out to the scene.
Okay. And in terms of civilians, were there any civilians on scene when you got there?
At that point, I wasn't made aware of all the civilians on scene until after we had spoken with Cortland Henry.
Okay. So you mentioned Cortland Henry. Who is that?
Cortland Henry is the driver of the vehicle, and he's also the co-defendant in this case.
And when you made contact with Mr. Henry, where was that?
They had him separate from everyone else. He was in a visiting a room, a treatment room. It was an actual hospital room with a door, not just a sliding shade. It actually was door, window, bed.
When you made contact with Mr. Henry, did you have any knowledge of the surveillance footage that's been in from the New Era studio that's been entered into evidence State 7?
No, ma'am. At that point, I came into it blindly.
So how did you treat Mr. Henry?
He was a victim of a crime.
So the ladies and gentlemen of the jury already heard the statement that you took. During the course of that statement, what things in that Mr. Henry said started setting off a little bit of alarm bells for you?
The biggest thing is where the crime allegedly had occurred. We were being told it was on Miramar Parkway, just west of Southwest 160, as close to 172 in that area there. But when we had the area walked out, we didn't find any shell casings, didn't find any shards of glass, and you're in a residential. Yes, there's businesses there, but on the south side is residential. As many bullet holes there was in that car. The commission, I think I saw at least 10, and we didn't get a single phone call.
Okay. So when you were there on scene, did you look at the car that was out there? You said you saw 10 bullet holes?
Yes, ma'am.
Did you notice any damage to the rims or the tires of the vehicle?
No, ma'am.
Did Mr. Henry tell you about a side swiping of a curb?
He said that when a vehicle pulled up next to him and started shooting, he lowered his position in the vehicle for his safety, and he hit the curb. But there wasn't finite damage, but you could tell it was over finite damage.
Was that explained during the course of his statement? That's from a prior accident?
Yes, ma'am, I believe so.
In terms of the way you treated him, what were you taking into account?
He's a victim of a crime. And sometimes when you experience very traumatic situations, you're not going to remember everything. And it's understandable you're going to be vague sometimes in your facts, and even if you're not from the area, you may be confused on the location. So our biggest thing was that we knew something happened. We knew it just didn't happen where they said it happened.
Why is it important for a law enforcement officer to know where something happened?
Well, we got to establish venue, which is then for jurisdiction for us to investigate the crime.
Speaking of venue, in what city, county, and state is Memorial Miramar Hospital?
So the city of Miramar, county of Broward, state of Florida.
And at that point, when you're making contact with Cortland Henry, does the name Janelle Dennings come up in any way, shape, or form?
Yes, ma'am.
Is there any indication that he was in the car told to you at that point?
No, ma'am.
You mentioned at some point in the statement another shooting off of I-95.
Yes, sir.
What investigation did you do to see how that was potentially related to this case?
I was able to get a hold of the detective on scene, which is Detective Curcio from Broward Sheriff's Office. And I was able to compare notes and discuss and figure out that that shooting was definitely not related to our shooting. They even had a weapon left on scene, which was, I believe, an assault style rifle. And we were able to immediately, determine that was not related to us.
In terms of being able to determine if different caliber weapons were used in those two shootings?
To the best of my recollection, there was different calibers. And at the end of the day, I know they made an arrest on that.
Okay.
Their facts didn't even match up to our facts.
So going on to potential suspects that Mr. Henry gave you, does he mention anyone or point the finger at anybody at that point?
I think he mentioned one name. They may have some beef up from Vero, from some guy named Bentley or something like that, but nothing that we could verify.
And in terms of the beef with Bentley, did he say if it was ended?
I believe his statement said it was taken care of, it was squashed.
With regards to an incident at Walmart, were you informed about a potential suspect there?
Yes, there was an incident a few months back at Walmart. I think during the statements, he said first the fight took place inside and it was outside. But I guess the necklace was stolen. It was posted online. But it didn't seem that anything really came of that either.
Okay, so Detective Moretti, based on your training and experience, have you had the opportunity to respond to various Walmarts across South Florida?
Yes.
Have you done criminal investigations regarding incidents or crimes that have occurred at those Walmarts?
Yes.
Based on that, do you know how long Walmart keeps video for?
Traditionally 30 days.
And in terms of the time period that was being described to you, was that within the 30 days?
It was way beyond 30 days.
So going back to that morning, did you go with Mr. Henry in the car with Detective Toyota to find out where this incident happened?
Mr. Henry rode with Detective Toyota, and it was just empty in the car.
And in terms of the evidence or anything that was reported back to you as the lead detective in this case that was recovered from the street surface of Miramar Parkway between I-75 and 184th?
There was no evidence recovered at all.
So, knowing that you had this location, are there businesses along Miramar Parkway that have surveillance footage?
Yes.
Were you able to go to some of those and retrieve some of that surveillance footage?
Yes.
So I'm going to start with what's been marked as the state's quadruple L, which is a composite of two photos. Counsel, you have a copy? Detective Marty, I'm showing you a composite of two images with been labeled state triple L. Do you recognize those two photos?
Yes, ma'am.
How do you recognize those two photos?
These are snapshots of the video from the McDonald's, the corner of 172 and Miramar Parkway.
And how do you recognize those?
Well, I'm the one that retrieved the video myself personally. But you can see at 3:46 a.m., you see a red vehicle going by, a red SUV. And then at 3:46:57, you see a silver SUV go by, which was consistent with the two vehicles.
Well, before we get into that, those photos fairly and accurately depict the video that you took from the McDonald's on October 26th of 2018. Are those two screenshots from the video that cover the time frame of this incident?
Yes, ma'am.
Have they been altered or changed in any way?
No, ma'am.
Right, this time the state would request a state quadruple L and the state 84.
Any objection?
No.
You're admitted.
States quadruple L will be marked states 84.
And permission to publish, Your Honor?
You may.
Starting at states 84, page 1, which is 10/26/2018, 34650.040. Detective Meridian, the screen in front of you is a touch screen, so I'm going to zoom in on the picture a little bit. And can you show the ladies and gentlemen of the jury what area of the screen you were talking about?
Right.
If you move, it should show the cursor a little bit better. And so what color did that vehicle appear to be?
Right.
and keeping it in the same location. Moving on to page 2, 346, 57, 840. Is that same circle around the vehicle that was in question in this photograph?
Yes, ma'am.
And does that appear to be a darker colored vehicle?
Yes, ma'am.
At what point did you learn about New Era Studios?
When we spoke with Mr. Henry, he informed us that they just came from the recording studios in Fort Lauderdale. And so 2 of our detectives then responded there, Detective Bertrand and Detective Toyota, to retrieve the video, just to go there to see what evidence they could recover.
Okay. Once the video was recovered, did you review it?
Yes, ma'am.
Okay. Approximately how far is it from the New Era 805 Northeast 4th Avenue in Fort Lauderdale to the Sunset Lake 40th Street Guardhouse?
About 30 miles.
And have you had the opportunity to drive that distance or look that route before?
Yes, ma'am.
With regards to the studio video, it's been admitted as State 7. Did you review this before or after the search warrant was conducted on the Jeep?
This was before.
So going to channel 4, 2:17:42 starting time. Fast forwarding here till 2:18:40. Were any man purses, satchels found in that gray Jeep?
No, ma'am.
Specifically, the beige one that's pictured at 2:18:40.
No, ma'am, we did not recover that.
Continuing forward to 2:19:05. Was a black satchel recovered?
No, ma'am.
Specifically the one that is seen in the individual in the black and white jacket?
Correct.
Okay. Did Mr. Henry have possession of either of those satchels or man purses at the hospital?
No, ma'am.
So after you learn about the studio video, do you have an occasion to respond to a location that's identified as 18521 Southwest 44th Street?
Yes, we went to that before the video was recovered. That was the location where the defendant was residing at the time.
And who else did you know lived there at that time?
I believe the defendant, co-defendant, Mr. Henry, Mr. Mills, Mr. Davis, Mr. Glass. I believe they were all living there, as well as the victims.
And in terms of the location of that address, do you know the name of the subdivision it's in?
I believe that's Sunset Lakes,
And where is Sunset Lakes? What city?
City of Miramar.
When you went to that 18521 Southwest 44th address, did you go inside?
No, ma'am.
Can you tell the ladies and gentlemen of the jury what it was like when you first got to that location?
At that point, we had already cleared from the hospital. It was probably, the sun was already coming up, so, maybe 7, 8 o'clock in the morning, maybe even a bit later. We went, there was no cars in the driveway. We went to the front door, knocked, looked in the windows. We didn't see anyone.
While you were on scene, did a vehicle pull up?
Yes.
What vehicle was that?
It's the red Mitsubishi.
And who was in that?
Driving it was Dontavius Withers and Adrian Davis.
Did you make contact with them?
Yes.
Without going into what they said, were you able to get a phone number from each of them?
Yes.
Did you see the defendant, Jamal Vance, there at that time?
No, ma'am.
Were you invited into the house?
No, ma'am.
In terms of the McDonald's video, when time and the continuity of when you did things, when did you go to McDonald's?
I believe that I went to McDonald's a week. This happened on a Friday, Saturday morning, and I was at McDonald's Monday morning.
Okay. So I'm going to go now to on October 26th. Did you do any additional evidence collection or interviewing of any individuals?
On the 26th?
Yes.
No, I just wrote the search warrant for the Jeep.
Okay. While you were at the hospital, you mentioned that you didn't see civilians when you first got there.
Correct.
Were there any civilians that you made contact with before you left?
Yes.
And who would those be?
There was some of the victim's family there, some of the Phillips family.
No, neither victim has the last name Phillips. You'll have to identify who those are.
The Phillips family is with Chris Thomas's family.
Okay.
There was also I didn't make contact with him. detective Bertrand did, Trayvon Glass, an Andrew, I forget his last name, he was there. I made contact with the defendant's mother, Jamie King.
Okay. And after you left the hospital and made contact with those individuals, did you do anything else other than writing the warrants and executing a warrant on the Great Jeep?
No, ma'am.
Explain to the ladies and gentlemen of the jury what you have to do to write a search warrant.
Search warrant is based upon probable cause. There's an affidavit, an application, and then there's the actual warrant. We write the warrant, the application, the affidavit, and then we send it to a state attorney. We find when the state attorney is on duty. Hopefully we get the $1 million warrant that we're up. So we send the warrant to them, they review it, and then if they approve it, then it goes to the judge. The judge will then sign it. At this point, we're doing an electronic warrant, so we could submit it electronically.
And in terms of the search of the Jeep, can you start searching it while you're waiting for the judge? Why not?
Because we don't have authorization to go into the Jeep. And we secure it, we can take it, we can hold it, but until that warrant is signed, we cannot touch that vehicle.
So after the warrant is signed, is executed, are you present for the execution of that search warrant?
Yes.
What?
I actually have to read the warrant to the vehicle. I know that sounds very strange. It's one of those procedures that's been done for years. I can never explain it, but if it's a house, we have to read it to the house. If it's a vehicle, we read it to the vehicle.
Is that why we see you holding papers with all these warrants?
Yes.
So after you read the warrant aloud and tell the people that are assisting you what you're looking for, what is your role while the warrant's being executed?
I step back. I don't get involved in that process.
Do you collect evidence at that point?
No, ma'am.
So you indicate which areas may be of interest for evidence collection?
I'll point out that, this is who was sitting where, this is what we have, but, that's their area of expertise.
After that warrant is executed on the gray Jeep, when are you made aware of the casing that's found in the backseat?
That night, when they collected it.
And going forward to October 27th of 2018, did you leave Broward County and travel to meet with other witnesses?
Yes, ma'am.
Where did you go?
We went up to, Vero Beach, into Gifford to make contact with some of the victims' family.
Okay. Did you have an opportunity to, without going into what was said, see Adrian Davis again?
I saw Agent Davis again. We saw Davis Withers again. I believe we saw Chris Thomas Sr. And I think if I'm not mistaken, the girlfriend of Chris Thomas as well.
Was there an occasion in which the application Snapchat was brought up?
Yes.
As a result of learning about a Snapchat, did you author a warrant for Snapchat?
Yes, ma'am.
So when you authored the warrant for Snapchat, which has already been admitted into evidence in various states, 61, what were you looking for?
I was looking for communications between Janelle Demons and Davis Withers.
And what were those communications supposedly going to show?
The communication was supposed to show that Janelle Demons sent a message.
Steve, I just want to clarify one thing. Prior to trial, I mispronounced the defendant's name. It's pronounced Demons, D-E-M-O-N-S. Lemons with a D is the way we explain it. And I know it's been pronounced different ways here, but it's pronounced Demons. All right? Detective, all right? Demons? Yes, thank you. Proceed.
Okay, so going into what's been previously offered into evidence as State 61. The account information, if you could publish what this says and make it as big as possible, as to who owned this particular Snapchat account.
Okay.
You could read?
Yes, it says the display name is Melly Montana. The email address associated with this is mellymontana@icloud.com. The phone number is 772-713-9807. And I guess I think they call it the vanity name YNW Melly.
Okay. And is that display name as it's indicated here?
Yes.
And in terms of the IP history, did you do any additional investigation or research into the IPs that were provided?
No.
Going into the.
I'm sorry. Is there objection? There's no objection. All right. Steve John, I'm sorry. We'll take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in present. Certainly no research. Just leave no opinion on your chairs. Thank you. Thank you. Let the record reflect the jury stepped out. Counsel Mann with the defendant. Who needs a record break? Can you raise it? Yes, sir. Mr. Dennis?
Yes.
Thank you.
I apologize for the rush.
No problem.
I'm going to show you how to clear this.
I apologize for pronouncing his name all the time.
You make everywhere you look has to be predetermined to prove your case and your theme. So the theme here is what?
I think the theme is here that Melly killed two of his best friends growing up, and I think that the forensic evidence was pretty powerful, in terms of them putting the forensics on. It made it hard for me to believe that he wasn't somehow involved. I mean, I think at the end of the day, we know that he was sitting in the seat that we saw him get into on the video when they left the studio. And I thought that, the use of the dowel rods was pretty, that's old school. I think they're using lasers these days, but like the dowel rods, in terms of the angles, it was compelling evidence. I think that I probably would have ended on that with that type of stuff, because if this guy's the last witness, then we're not going to hear that statement that you were talking about from the snaps. And that is ultimately, you are definitely going to hear about that in the defense's case in chief, and you're certainly going to hear about it in the closings.
Yeah, but you know what, Bob, and you and I have been around the trial, so is Christy with the dowel rods. I've had a lot of cases with them. They're shooting in the back of the neck, but all somebody had to do was turn like this, and then the shot comes from someplace else, and if the bullet's not found. So I assume the defense is going to go there if they have an expert witness talking about it. But we'll see. We're going to take a break, and we'll come back. We'll be back to the scintillating testimony in the courtroom as the prosecution seeks to end their case on a strong note.
Jury enter. Attorney General, thank you. Please be seated. Let the record once again reflect the presence of our jury, the defendant, the evidence, the counsel, the assistant state attorney, all witness protection marks already remain on the stand. Friday, I think you're still under direct examination. You're ready to proceed.
Okay, Detective Reddy, we had started talking about the Snapchat records. Before we go in and publish the rest of those, in your investigation, were you able to determine nicknames and legal names for various individuals that are involved in this case?
Yes, ma'am.
So starting with the defendant, did he have a nickname that he was commonly referred to as?
Melly.
Okay.
On Williams,
Hold that microphone, it got pushed in there. Thank you.
on Williams' phone, he was known as Smurf. I'm sorry, on Williams' phone, he was known as Slim.
Okay.
Some various other names.
So in terms of for Portland Henry, did he have a nickname you learned during the course of this case?
Yes, Portland Henry actually went by the name of Ward.
Okay. And for Mariah Hamilton, did she have a nickname?
The one most commonly used was Riri.
So in going through the messages, and I'm going to zoom out just a little bit on this. Like for example, Friday, November 9th, 2032:05 UTC. What is the difference between UTC time and November of 2018 post time change?
It's UTC is Universal Time Code, which is 5 hours ahead of our current time zone.
And that's in November. What about in October? What was the difference before the time change?
It was 4 hours time difference. I think the time change was actual date was November 4th.
Okay. So in terms of this message, there's a lot of kind of gibberish characters at the end after it says kill me. What are those gibberish characters?
Usually those are emojis that when it's printed, that's how it looks on paper.
And so I'm going to make sure we understand, and that clearly, ladies and gentlemen of the jury, what these columns each stand for. So starting with the far left column, what is that column?
Is the ID column, I guess the two accounts that are speaking with each other.
Okay. The next column, what is it?
It's the from, that's to be the sender, and then the next column is to, which would be the receiver of the message.
Okay, and then under where it says body,
That is the actual message.
and over here on timestamp, what would that reflect in that last column?
That was in the actual time that the message was sent in UTC, and you would just subtract 5 hours off of that. That's
Okay. I'm not going to make you do the math right now, because that's we'll get to that in a second. So I want to go to October 26th of 2018. Were there any messages captured as part of the search warrant on October 26th, 2018?
No, ma'am.
In terms of the message here on Tuesday, October 23rd, who is identifying themselves as using this Snapchat account?
The name being used is Melly.
So were you able to determine who was that baby 01?
Yes, that was Mariah Hamilton.
How could you tell that?
The context of the conversation between them two, as well as interviewing Ms. Hamilton.
Were there pictures that were sent back and forth that also include her photograph in these?
Yes, there was photographs between as well.
So going to this message here, which is Friday, November 9th, 2023, 12 UTC 2018. Now I am going to ask you to do the subtract 5 math on that one.
What you see there is 2023 UTC, which would be 8:23 UTC PM time. However, but transferring it back to Eastern Standard Time, it would be 3:23 PM.
And what I'm going to do here, so it's clear on the columns again, go back to the first page of the chat. So this message is going to the defendant's account.
Correct.
Okay. What does Ms. Hamilton say to the defendant?
Objection. Document speaks for itself.
If he can read it and publish it?
Like I said before, your stupid ass blocked me. You moved very effing funny. TF. You know what that means. BITCH. You know what that wasn't tagged on that girl page, but your dumbass just lied about everything. I peep every effing thing, and I always watch how a MF move, and this is how you've gone move, bitch. I'm not going to come around no more, period. Don't post me on your damn Snapchat if you're scared to post me on your Instagram for your bitches, period. TF. And I won't go to another show neither. Be trying to have Portland go to the shows with you so you can bring bitches and shit back to the hotel. Everything is so cool. I peep everything. You're one sneaky lying bitch boy. F you. I'm standing on my shit this time. Bet you won't hear from me again after today. And then there's 3 emojis, which doesn't translate when you put it in.
May we approach?
Yes.
Who is that from?
It's from Melly, Montana to Dead Baby B01.
Okay. Then the next message from that Melly, Montana, and this is November 9th, 2018, 2025-19 UTC for council.
Judges, may I have a continuing objection so I don't have to interrupt the state on this?
That's fine now.
Thank you. Continuing objection.
And so what does Melly Montana say to that individual on November 9th of 2018? I'm gonna try and make it big, sorry.
No, that's fine. I just want to be a quick review. Caution. Bitch, I'm not fit to leave board with Tao after what you stuck on me being with, but you think that's all I think about. This N-word saved my life. He's coming with a K everywhere with me, cuz with a K, if them crackers come grab him, it's my fault. You forgot 3 question marks.
So then I'm gonna go, so it's clear. The messages chronologically, how do they go in this exhibit?
They go by the time frame. You can see it's a sequential argument between 2 individuals, the same individuals.
So let me ask you a better question. The message here below, that says 2025-39, is the message that's above it at 2027-26 prior to or after?
Is after.
Okay. So in terms of reading the sequence, do you go from the bottom of the page up?
From the bottom up.
Okay. So going now to the next message, again, November 9th, 2025, 39 UTC from Melly Montana to that baby message. What does it say?
Dumbass ho, you so selfish and young-minded. Don't even think about what I'm going through.
Okay, and then moving on to the message from this November 9th, 2027 UTC, 2018.
Fuck ass ho, you don't. FWN, which means fuck with me. Anyways, you just use me like the rest to do keep all that shit ho on God, on my mama. He was on her shit.
Okay. So continue on to the next message from Melly Montana, and this one is at November 9th, 2027-26 UTC. And that message here from Melly Montana again, what does this one say?
You know I don't want board brown yay like that stupid asshole.
The next message, which is then 2027-23 UTC for the record, from, again, Melly Montana.
Shit deeper than just bitches.
So continuing up, moving on to Friday, November 9th, 2029, 20 UTC, 2018. Message from Melly Montana to, again, that baby. What does that one say?
You don't fuck with me anyways. I peeped it. You can slide, but God knows I wasn't in her shit. N-word will end real dumb. Breaking your shit, you spoiled everything was given to you, you bitch. You act like a N-word, some bitch slide. I keep working with cuz at the end of the day, he did one of the realest shit in my life.
Okay. So this argument continues on, so you described it. So the response to that from that lady to Melly, Montana, which is on 20/30/26, Friday, November 9th, 2018. What is her response?
Oh, I am. Stop messaging. There's nothing else to say. Still peep everything, hun, and I says it's fine.
The response from Melly, Montana on Friday, November 9th,
I can
2030.
try to pre-read it to make sure
Yes.
cautious what I say. I'm gonna keep him with me. He ain't never say half the shit you said. I put you way before him at one point. He never said none, bitch, stay away. You don't love nobody. For real, you heartless. I see it, bitch. Stay away, ho. You just want to break a N-word.
So going up to Friday, November 9th, 2031, UTC. Again, the from column, Melly, Montana. What does that message state?
I'll real deal.
And then the next one here.
But you dropped 5
My apologies, sorry, at the top.
in the end. Never mind.
So then the response from that lady on Friday, November 9th at 2018, 2032-05 UTC.
She responded, "Kill me," with a question mark with some emojis that were unreal.
Okay. So after you reviewed the Snapchat records and you weren't able to confirm or deny anything about a Snapchat communication on October 26th, 2018, what was the next step in your investigation on, let's see, so that was October 27th, we talked about in Vero Beach. I want to go to October 29th of 2018. What did you do in terms of search warrants and cell phone data?
I authored 2 search warrants, one to Sprint, one to T-Mobile. The Sprint one was to Deltavius Withers' cell phone, as well as one of the victims, Chris Thomas's.
Okay.
And then the other search warrant was for the phone of the defendant. As well.
Objection.
What's the objection?
Cause for divorce. And they have not established a predicate that it's in fact our client's cell phone.
What's your sidewalk?
The cell phone number for Anthony Williams, I transposed the last 2 digits, so the data came back as well.
Were you able to catch that mistake and fix it?
Yes.
You make mistakes, you're a human being?
I make mistakes. I'll continue to make mistakes. Not perfect. Never said I was.
Okay. So once you, on October 29th, you analyze the cell, you do the warrants for the cell phone data.
Yes.
You did it right away like that?
Yeah.
Okay. Explain to the ladies and the jury about when you first got some of that data back.
We first, at the time, Sprint and T-Mobile were 2 separate entities. They have now since combined. We traditionally got Sprint back quicker. I think we got it back within a week. I think it took about 2 weeks for the other number, got for the T-Mobile providers. So when we first got the Sprint records back, at the time, Sprint just wasn't as accurate as T-Mobile is.
Okay. In terms of, do you mean accurate or precise?
More precise. I mean, T-Mobile has the true timing advance, which at the time Sprint was using for call measurement data, but we didn't have a lot of for call measurement data, which is distance and angle from the tower to the device, which is just estimated.
So when you get the Sprint data, do you have any idea of how far away a particular device may have been from the tower?
At that time, no.
In terms of what information were you able to glean from the Sprint data as to where you need to start looking for your next potential lead?
It took us out to US 27 because the cell phone for Chris Thomas hit on the tower out on US 27 near Holiday Park, and that's where we started our.
So tell the ladies and gentlemen of the jury, when you went out to US 27, when you first got the Sprint records, what did you do?
I plotted it, analyzed the data. It took us out to US 27. Detective Bertrand and I actually walked 2 miles of US 27 because we were on 27 looking for anything, shards of glass, projectile, spent casings. We weren't near the crime scene at that point. We tried to, we went into the mobile home park, come across some people, never heard gunfire that night, didn't see anyone out there, not the vehicles, nothing.
Okay. So in terms of about what date was this that you were out walking on US 27?
It was about the first week of November, November 7th or 9th, something like that.
Okay. So once you obtain the T-Mobile records, how does that refocus your investigation?
It was able to dial in a little more specific. It was able to direct us out to US 27 in Pembroke.
When you first get the T-Mobile records, do you go through and verify and see some of the known locations? For example, the studio.
Yes.
So in terms of the T-Mobile records, I want to draw your attention to, and if I can find this next piece of this is the T-Mobile records, which are in evidence. State 63. So Detective Moretti, when you're looking at the information in the T-Mobile records, I'm going to start by pulling up the 772-7103 records. So I'm going to publish part of States 63, which has been previously admitted into evidence. We're going to go to 205-8127 records, the timing advance LTE. So going.
This is which phone number?
772-713-9807. That's right up there at the top in tiny print.
Oh, okay.
So I want to go down for times on this one to 3:18 a.m. At 3:18 a.m., there's a latitude and a longitude that is listed on that particular item.
Yes, ma'am.
Do you, at that point, verify the studio video versus where that latitude and longitude is showing the network things the phone is?
It was within a block of the studio.
And has that been reduced to a map?
Yes, ma'am.
Okay. Showing defense counsel what's been marked as states quadruple M, what's been previously shown to defense counsel, all of these maps before he came in. Okay, Detective Moretti, I'm showing it's been labeled as states quadruple M. Do you recognize this?
Okay. Yes, ma'am.
And how do you recognize this?
That is the map, Google map of the area where the recording studio is at.
Does this Google map fairly and accurately depict the latitude and longitude coordinate here at 318, 26.313371?
Yes, ma'am.
And negative 80.138733?
Yes, ma'am.
Any alterations or deletions?
No, ma'am.
Your Honor, at this time, the state will request the states for M in as state 85.
Can I call Diane, please?
Sure.
They didn't get an objection. You're more than welcome.
Detective, this is dealing with cell phone analysis, correct?
Yes, sir.
And primarily, can you get that? Primarily Cellhawk and Cellbright.
So, two different devices. Cellbright is for the digital forensic examination of the cell phone, and Cellhawk is the platform we use to plot the actual CDRs and timing advance records.
And how many hours have you taken in training in those two areas?
The cell phones and the
Cellhawk and Cellbright?
Probably well over 100 hours.
Okay, and have you received any certifications?
Certification from Cellhawk as well as from CASVIZ, which is what the FBI uses.
And have you ever trained other officers or supervised other people in digital forensic analysis?
On digital forensic analysis, no. Cell sites, yes.
And is there a particular process you follow when you conduct a cellular forensic examination?
You mean when we take data from the cellular device?
Yeah.
Once you,
Objection outside the scope, Your Honor. We're not talking about the device yet.
I'm sorry, I'm sorry.
This was printed, in other words, how they determined the latitude and longitude.
how T-Mobile? did
Yes.
it? No, I did not know how they produce it.
I renew my objection.
Anything else?
No.
Thank you. Objection notes overruled. Proceed.
So Detective Moretti at this point, or sorry, Your Honor, state offers states quadruple M as states 85.
Any additional objections, counsel?
No, sir.
Objection notes overruled.
States quadruple M will be more states 80.
Okay. Permission to publish?
You may.
And so Detective Moretti, this is it. I have the back of it shows the latitude and longitude on here, but that covers up quite a bit of the map. So after you have an opportunity to publish this, I'm going to switch it to the other side, which then just has the indication of the marker.
Okay, it's fine now.
So Detective Moretti, in terms of the address that's previously been specified as 805 Northeast 4th Avenue. Where was that determined to be on this map? And you can, okay, is it drawing on there?
I'll get it.
And so did you personally go out to that location at various times during the course of this investigation?
Yes, ma'am.
So I'm going to go forward now. After you looked at that particular coordinate, I want to go to 335. Which is on this particular CDR, again, states 63 previously in evidence, line 127 of the 772713987.
Yes, sir.
And previously shown to the defense counsel, marked as states quadruple N.
I will ask one question. Okay. With the court's permission, can I ask one question?
Yes, go ahead.
You're merely reading off this bill or this chart, correct?
Correct, sir.
You don't know how it was derived.
No, sir.
Same objection.
So, Detective, I'm showing you what's been previously marked as states quadruple N for identification purposes only.
It recognizes.
And then going back to the states quadruple N fairly and accurately depicts the latitude of 26.116584 and the latitude of negative 80.324128.
Yes, ma'am.
Here on, and does this fairly and accurately depict the location of that on this map?
Yes, ma'am.
Here at this time, the state would move state quadruple N as state 86.
Any objection?
Same objection.
Thank you. Objection notes overruled. It'll be admitted.
Thank you.
States quadruple M will be marked states 86.
Detective Moretti, again, showing you first the coordinates with the latitude and longitude. And if, once you're able to kind of familiarize yourself with that, I will flip it over to the other side.
You can flip it.
Okay. And here on states 86, can you show the ladies and gentlemen of the jury where the whole camera is in the express lanes in this photo approximately? And Detective Moretti, did you obtain camera footage from the Department of Transportation to cover this time of 3:35 a.m.
Yes, ma'am.
So I want to continue forward now in your investigation to 3:47 a.m. Line 136 on this particular CDR for 772-713-9807.
136, you said?
136. Detective, I'm showing you what's been previously marked and shown to defense counsel as states quadruple O for identification purposes only. Do you recognize states quadruple O?
Yes, ma'am.
So states quadruple O fairly and accurately depicts the latitude of 25.977994 and the longitude of negative 80.374577 as depicted on line 136. Correct. At this time, the state would request to move states quadruple O in and publish.
Any objection?
May I ask the same question?
Flores?
You're just reading from that document, correct?
Yes, sir.
That you did not create, correct?
Correct.
And you have no idea how it was
Objection,
created.
Mr.
Same.
Objection.
No, it's overruled.
Okay, so publishing what is now states 87. Travis? 87?
87. Quadruple O will be marked states 87.
So Detective Moretti, in terms of the location of this particular pin or GPS marker, are you familiar with the city it's in?
This is in the city of Miramar. This is Miramar Parkway and 172 Avenue.
Okay, so I'm gonna go ahead and turn it over on the other side. Is there a fast food establishment located at the corner of 172nd Avenue and Miramar Parkway?
Yes, ma'am.
Could you please point that out for the ladies and gentlemen of the jury by circling it? And in terms of the photos that were previously introduced as states 82, are those from that same account?
Yes, ma'am.
So Detective Moretti, I'm gonna go forward during your investigation and go to what time has been listed as 3:53 a.m. That is line 145 of the 772-713-9807 CDR for defense counsel. Showing what's been previously marked as states quadruple P and shown to defense counsel prior to this afternoon's court session. Detective Moretti, do you recognize states quadruple P?
Yes, it's High Boulevard.
And does the latitude and longitude of 26.007627 and negative 80.411552 fairly and accurately depict the latitude and longitude on line 145 of the CDR in front of you?
Yes, ma'am.
Here at this time, the state would request to move into evidence as states quadruple P, the state's 88.
Any objection?
Same objection, and I would be asking the same questions, which we all know would be his answers.
Any objection? No, it's overruled. It'll be admitted.
Okay.
States quadruple P marked states 87. 88.
88. Thank you. So publishing states 88. Detective Moretti, in terms of the location that we are looking at right here, where is this, once you have this GPS pin?
Yes.
Okay, I'm gonna go ahead and flip over to the other side. Again, the same map, just without the details on it.
You want me to identify the Montessori school or just identify the GPS coordinates?
You read my mind. The Montessori Academy, please. Did you obtain video from the Montessori Academy?
Yes, ma'am.
Okay. Here at this time, the state would request to publish what's been previously admitted into evidence as state 80.
I'm sorry, which is the 80 or 80?
82. That's the concern.
Yes, you may. It's in evidence.
I'm gonna go ahead and switch to the other computer and also work a little bit better. Check ready, is this the footage you obtained from the Montessori Academy?
Yes, ma'am.
Okay, and so starting at 3:52, or 3:53, my apologies, I'm gonna publish from 3:53 through 4:20. You guys see the voice? Detective Ready, based on your familiarity with this area and its location, the video that says US Tower East View, what direction, cardinal direction does it face?
It's facing towards the east, capturing vehicles going westbound.
And the bottom, the US West parking, what road is it facing in what direction?
It's still facing Hines Boulevard. It's facing west, and it would actually capture vehicles going east and west, but it's more focused on vehicles going eastbound.
Okay. And so when you say more focused on vehicles going eastbound, you mean closer to the camera? Would be that good?
Yes, closer to the camera.
Detective Ready, in reviewing this footage at 4:06, was there a dark colored vehicle traveling westbound?
Yes, ma'am.
Was there a red vehicle traveling westbound in connection with the
East or west, no red vehicles traveling.
And that was at 3:53 as well?
353 as well as 406, there was just the one solo vehicle traveling by itself.
And that concludes publishing through 4:20 a.m. So going back to our 772-713-9807 CDR. You just talked about 3:53 a.m. in line 145. I want to skip ahead to 406, and we'll come back to 403 in just a minute. So 406 is here in line 156. It's been labeled as states quadruple Q for identification purposes, previously shown to the Vice Council. Detective Ready, I'm showing this in marked as states triple Q for identification purposes only. Straight states triple Q, what is that?
This is Pine Boulevard and 196 Avenue.
Okay, so it's the latitude and longitude reflected on states triple Q of 26.010021 and negative 80.4088939.
Yes, ma'am.
Accurately reflect the line 156 of the CDR we've been looking at.
Yes, ma'am.
And does that point on the map accurately and clearly depict where that location is in the world?
Yes, ma'am.
Here at this time, the state was requesting that states quadruple Q in as states 89.
Any objection?
I know it's shocking, but the same objection.
Noted, overruled. Will be admitted.
And permission to publish? Okay, and Detective, this is a 4:06 a.m. If you would be so kind as to show the Montessori Academy again. So I want to go back now to 4:03 a.m., which is highlighted in line 154 of this CDR or timing advance from T-Mobile for 772-713-9807. Do you know how the environment data is done on this CDR?
Are you asking how T-Mobile produces it?
Yes.
Basically, it's from what it's determining or it's interpreting the location of the phone based upon its environment. And it either says mobile, outdoor, stationary.
Objection. May we approach this?
And then here, for example, column 5, environment, indicates whether the call was determined to be indoor, mobile, or outdoor stationary.
Okay.
As to what the witness is going to say about the new coordinates here, I think you said it was at 4:03 a.m. on phone 9807, last four digits.
Yes, sir.
And at that location, where's this going to be at?
That location is going to be at Pembroke Road in US 27,
And
approximately 100 meters, 100 feet.
The 9807 number was 400 feet from the crime scene, and Anthony Williams' phone was 100 meters from the scene.
And you're saying that, going back to the first exhibit you had on the location there, you sort of saying that on one of these lines, it basically indicates,
Yes, Your Honor.
under environment, line 5.
154, which is the coordinate that I just showed you, that's been marked as states quadruple R for identification, the Pembroke Road in US 27. That is the outdoor stationary notification that the T-Mobile network is saying as to the location of the phone.
Thank you. And your objection is?
Our objection is that the FBI agent Brendan Collins testified that not only can he not give an accurate location, but cannot tell and does not use the environment as absolutely unreliable. And the reason they brought in the FBI agent, so the court knows later down the line, and listed him and brought him in late in the case, several years, I believe, later, is because they realized that the individual, specifically this detective, was not qualified to testify to the items that the court has, that the state is now inquiring. And that was the sole purpose of adding him late in the game and making us take his deposition rather late in the game. I mean, that's what the FBI agent testified to. The environment is absolutely unreliable. He doesn't even know how it works. And they never, ever use it in any jurisdiction that the FBI is working on. And the mere fact that that prints, whatever it prints, means nothing.
Judge, could I ask you 5 minutes just to find in the transcripts where he did it so I can direct the court directly to where the FBI agent testified, not only in trial?
Go right ahead.
Thank you.
Will we be in recess during that period of time?
Yeah, I'm just trying to think of, is there anything else you want to share with me, Ms. Brown?
No, Your Honor, not this one.
All right, so we'll be in recess. You show me what you were talking about in the transcript of the Brendan.
Thank you, Judge.
When it came to environmental issues, he said it can affect the calculation meters, not miles, small deviation.
Your Honor, I think that was in regards to foliage, meteorological issues and things like that. That was the environment. In terms of this particular on the environment data or column, my recollection that this was not asked on cross by Ms. Liberty, but that he said he does not rely upon this in doing his calculations. However, you could look at other collateral sources and corroborate whether this was or was not accurate.
The mere fact that this is burden shifting. The burden is on the proponent of the evidence to establish its authenticity and that it is what it purports to be. The mere fact that the state is saying that the defense hasn't shown that it's not reliable is in fact an admission that the state has not shown that it is. And the only evidence that they're pointing to is a hearsay out-of-court statement by somebody at T-Mobile purporting to describe how it works and not even giving any indication as to the reliability of that that is pertinent to our objection here, which is how are you telling whether the person is inside or outside? I have one of these apps to track my daughter's movement. She's 2 blocks down the road at a friend. It's saying that she's at the house. So this whole notion, one, that it is precise, and two, that it can tell with specificity and reliability sufficient for a jury to rely upon in a murder case, that you are inside or outside when they have no expert laying that predicate. And it is required of them to do so before attempting through this witness to muscling that information under the guise of it being accurate when it in fact is not. And if they had a witness who could establish that it was, one, they should find out it was, and two, they should present it before trying to present this information. They can't just say, well, the T-Mobile records say it. Because one, it doesn't say it. And two, even if it did say it, it does not establish its reliability.
Hold on.
Yes, sir.
Anything else?
No.
Counsel, respectfully, I overrule the objection. It appears to me that that's all filed for cross-examination. This is all part of the document that's in evidence. The document says what it says. And so, objection notice overruled. Can we get the jury back in?
Jurors entering.
Ladies and gentlemen, thank you. Please be seated. The record once again reflects the presence of our jury, the defendant, Mr. Dennis, his counsel, the state attorney, the witness remains on the stand. Counsel, if you would proceed, please.
Thank you. Okay. So, Detective Moretti, we're now going to line 154, and that is at 4:03 a.m., 10/26/2018. We're talking briefly about the environment column. On line 154, the environment column under D, what does it say?
Outdoor stationary.
So I'm now approaching with what's been marked as state quadruple R for identification purposes and previously shown to defense. Do you recognize this?
Yes, ma'am.
Does state's quadruple R fairly and accurately depict the latitude and longitude here on line 154 of 25.993063 and negative 80.428081?
Yes, ma'am.
And is that an accurate location as to where that GPS point is in the world?
Yes, ma'am.
Here at this time, the state would request to move into evidence state's quadruple R as state's 90.
Any objection not previously raised?
Not previously raised.
Thank you. Objection not overruled.
Yeah.
It'll be admitted.
R, marked states 90.
So Detective Moretti, I want to go here to publishing states 90. Once you have your bearings on this, point from the 9807 phone, I'm going to switch over to the other side at 4:03 a.m. What area does this depict?
This is the actual crime scene on US 27 and Pembroke Road.
And approximately where along Pembroke Road on this map were those casings discovered?
It was on the south side of the road, about 820 meters from US 27. 820 feet from US 27, and approximately where the GPS coordinated that.
Okay. So I want to talk a little bit about the next point in the map next to its home. So going forward now to 4:42 a.m. That is line 185 for defense counsel, showing what's been previously marked as state's quadruple S and shown to defense counsel prior for identification purposes only. Showing you state's quadruple S for identification. Detective Moretti, do you recognize that?
It is Pembroke Road and Southwest 178 Avenue, which is in our jurisdiction of Miramar.
Does the latitude of 25.989873 and longitude of negative 80.386462 rather than accurately depict the latitude and longitude from line 185 of the 772713907 cell phone records?
Yes, ma'am.
Here at this time, the state would request to move state quadruple S in and publish to the jury.
Any objection?
Same objection.
Overruled. It'll be admitted.
States quadruple S will be marked states 91.
Okay. So Detective Moretti first showing with the information on the back. And then publishing on just the point. So Detective Moretti, can you describe to ladies and gentlemen of the jury, what is Southwest 178th Avenue, south of Pembroke Road?
It's a subdevelopment. It's called Silver Lakes within the city of Miramar. The area we're looking at is south of Pembroke Road.
And you said it's a development. Is that commercial or residential?
Residential development.
And so this was 4:42 a.m. Going forward, showing has been marked as state quadruple T. It's been previously shown to defense counsel on that for identification purposes only, as well as approaching with states 71. Let me show defense counsel on state 71. State 71, page 20. Showing you as part of state 71, page 20. In blue, there is an address in that message. Can you read that address aloud?
3220 Southwest 192nd Avenue, Miramar, Florida, 33029.
And in terms of showing you now what's been marked as state quadruple T for identification purposes only. I'll show you all of the exhibit first and ask you a couple questions. So Detective Moretti, I'm going to go forward now to 8:46 a.m. Which is reflected on line 315 of this CDR. The states has been marked for identification as states quadruple T, fairly and accurately identify the latitude and longitude of 25.977759 and negative 80.4054779 on the blue dot.
Yes, sir.
The states what's been marked as for identification as states quadruple T, fairly and accurately identify the location of 3220 Southwest 197th Avenue, Miramar, Florida, on that map.
Yes, ma'am.
And do those fairly accurately depict those locations in Miramar, Florida?
Yes, ma'am.
Here at this time, the state would request to move in states quadruple T, states 92.
Same objection?
Same objection.
Overruled. It'll be admitted.
States quadruple T will be marked states 92.
So I'm going to take back states 71 again. And publishing for the ladies and gentlemen of the jury, the address that you just read aloud. And Detective Moretti, if you'd be so kind as to say the date and time that address and message were sent and read.
It was, let's see, it was read, sent on 4:45, 4:46 a.m. and actually, okay, it was sent on 10/26/2018 at 4:45, 46 a.m. and it was read on 4:45, 50 a.m.
Okay. So now going to states 92. First showing that same address. And so it's clear for the record, the address on this map is indicated by what color pinpoint?
Green.
Okay. Going now to the latitude and longitude that we previously discussed.
And it is blue.
Okay. And so now to take them without the. Okay. Detective Moretti, in terms of the address that we just talked about, that 3220 address, what subdevelopment was that located in?
That was in Sunset Lakes.
Is that the same subdivision as that 18541 address we talked about earlier today?
It's the same, same development, but not the actual same sub-community.
Approximately how far apart are they?
They're about maybe less than a mile.
Okay. After you reviewed these coordinates and had some idea of a path of travel and location, did you go and try locate any other surveillance footage that would be useful in the presentation of this case?
We got the video from the turnpike, from 595.
Okay.
We got the video from the McDonald's. There was a video from the Montessori School. We were on US 27 looking for video, which we did not recover any.
Okay. In terms of the cameras on US 27, what did you learn about those?
The video was much to our surprise that those cameras did not record.
And so the initial date of when you obtained the T-Mobile records, do you recall what date that was?
I believe it was, the initial records was the 9th of November.
Okay. So after November 9th, you obtained the Montessori School footage?
Yes, ma'am.
Prior to getting those T-Mobile records, did you have any indication that Pines Boulevard was an area where you should be looking for video surveillance?
Prior to the T-Mobile records?
Prior to the T-Mobile?
No, ma'am.
Okay. So after you got the T-Mobile, did you look for other video on Pines Boulevard or assign someone to do so on the east side of 172nd?
Yes, ma'am.
Were they successful in obtaining any footage?
No, ma'am.
Okay. Going forward on November 21st, did you have the opportunity to respond out to the location of Pembroke Road and US 27?
Yes, ma'am.
Can you describe to the ladies and gentlemen of the jury a little bit of the geography of that location?
It's an isolated road in the Everglades off of US 27. There's not a lot out there. There's a waste management dump. It's not well lit. Travel in the middle of the night. It's dark. The roads aren't identified. No street lamps. It's a very desolate place in the middle of the Everglades.
In terms of when you were getting there on the west side of US 27, what terrain features are there?
On the west side of US 27 is a canal that runs north and south, and that is marshy swamp areas.
Okay. To get on going now, start to ladies and gentlemen of the jury, 208th Avenue. Where does that road run?
It runs north and south. It connects Pembroke Road to Pine Boulevard. However, on each side, north and south, there's a gate that prohibits any travel.
Okay. Do you know what is located on that street as to why it is?
A fire train academy is located on there.
And what jurisdiction is between Pines and Pembroke Road?
Their jurisdiction, Pembroke Pines jurisdiction starts in the middle of Pembroke Road. We have the south side of Pembroke Road. They have the north side of Pembroke Road, and the line in between the yellow line in between the guys are two cities.
Okay. So now you talked about, so on US 27 going now from west to east on Pembroke Road. What's on either side of the road?
On Pembroke Road, it's marshy swamp area. There's absolutely nothing there.
When you get to the far eastern edge of Pembroke Road and you access it from US 27, is that open to the public?
No, it's a closed area because of the waste management dump out there, and it doesn't even connect all the way through. It goes maybe another quarter mile in, and then is the entrance to the dump, and that's it.
Okay. Is there a gate at the entrance to the waste management facility?
Yes, ma'am.
Is there an additional gate at the far western end of Pembroke Road? Or, I'm sorry, the eastern end of the western part?
Yes.
Would it be more helpful if I showed you a map to describe this?
Yes, ma'am.
Showing defense counsel within previously marked estates quadruple view. Detective Wright, I'm showing you this in previously marked estates quadruple view. So don't go to juries yet. Do you recognize that map?
Yes, ma'am.
Does that map fairly and accurately depict the geographical location you just described?
Yes, ma'am.
Here at this time, the state would request to move state quadruple view in as states 93.
Any objection? No. It's admitted. What's the number, Travis?
93.
Thank you.
Okay, Detective Marty, I'm going to put this up here to publish. And so we're going to start over here on US 27. Could you indicate on the map up ahead, and you can either use your finger or you want to go really old school with a pointer. Take your pick.
If I use a pointer.
Could you indicate that canal that you indicated on the west side of US 27?
You're going north and south, running parallel with US 27 Canal Bridge.
Okay, so I'm going to move this over a little bit. I'm going now to show the 208th Avenue. Can you show the ladies and gentlemen of the jury where the gate is on the south end of 208th Avenue?
There's a gate right here.
Okay. And will you show the gate at the eastern edge of the western part of Pembroke Road as to where traffic is stopped?
Repeat that again?
Can you show the gate at the eastern edge of the western part of Pembroke Road? And in terms of the waste management facility, is that indicated and shown on this map?
Yes, ma'am.
And where is that?
Right where it says waste management?
And in terms of the access to that, is there a gate for there as well? Sorry, move that.
That was actually,
We just learned that if you touch on that screen, it works too. Okay, Detective Marty, if you're doing your seat. Detective, did you have an opportunity with the Brown Sheriff's Office Aviation Unit to travel from the studio at 805 Northeast 4th Avenue
yes, ma'am.
to the location of Pembroke Road and US 27 via helicopter?
Yes, ma'am.
Was there a video of that flight captured?
Yes, ma'am.
Does it fairly and accurately depict the points of travel that you refer to from the College of Health Records and the timing events of the two funding?
Yes, ma'am.
So I also want to talk about, did you have an occasion at approximately 3:20 in the morning to go to 805 Northeast 4th Avenue in a vehicle?
Yes, ma'am.
Did you then travel from that location across 595 to I-75 to Miramar Parkway and then out to the location of Pembroke Road and US 27?
Yes, ma'am.
Was that filmed with video to fairly and accurately show the conditions at 4 a.m.?
Yes, ma'am.
Okay. So I'm showing defense counsel what's been previously marked as quadruple J for aviation and states quadruple K for the next one. Right. Detective Marty, approaching and showing you what's been previously marked for identification purposes only, states quadruple J and quadruple K. Do you recognize those items?
Yes, my initials and badge numbers on it.
Did you have an opportunity to review those before you came in here to testify today?
Yes, ma'am.
Did they fairly and accurately depict the flight from 805 Northeast 4th Avenue to the location and as well as the dark condition driving?
Yes, ma'am.
Your Honor, at this time, the state would request to move in states quadruple J and states quadruple K at states 94 and 5.
May I ask one or two questions?
Yes.
And do it from here.
Sure.
I'm getting tired. What day did you do the helicopter trip?
About a month ago, that one, the exact date would be on the video.
I'm sorry, a month ago?
About a month ago, sir.
2023?
Yes, sir.
So that would be June of 23?
Yes, sir.
While we were in trial?
No, it was good before the trial started.
Picking a jury then?
I don't know, sir.
Okay, June of 23.
No, it's the same time I call this objection.
Well, it's just a predicate. I'm sorry, Jeff.
No problem. Two of us can't talk at one time, but in any event, proceed, Councilman.
The nighttime driving at 3:20, you said?
3:21, yes, sir.
What day did you do that?
It's probably about maybe 3 or 4 months ago.
So that would have been in
Maybe April.
April of 23?
Yes, sir.
Did you look at any of the conditions, whether or not there were any accidents in 18 when this occurred?
No, sir.
Did you look at whether or not the weather conditions were the same as when you went out in June and April of this year?
No, sir.
Objection on predicate. Foundation and relevancy.
Done? Are you done?
Yes, sir. I'm sorry.
Can I see sidebar, please?
on the computer here. Did you select a time and date to do the video, so it would be the same in terms of the daylight savings time and the lighting conditions on that day?
We did it at the same exact time as the incident.
Okay. And so I'm gonna show you what is marked by identification as states quadruple K. And looking on the date of the video creation, is that refresh your recollection as to when it was done?
Yes, ma'am.
And when was that done?
That was March 10th, 2022 at 3 a.m.
And in terms of the weather conditions on March of 2022, were they the same or substantially similar to that of October 26th of 2018?
Substantially similar.
In terms of the lighting conditions, were they the same or substantially similar at the locations at US 27 as they were in 2018?
Substantially similar.
Have there been any additional lighting or streetlights installed?
No, ma'am.
Have there been any removed from the location of Pembroke Road and US 27?
No, ma'am.
Does that video fairly and accurately depict how US 27 and Pembroke Road looked in both 2022 as well as 2018?
Yes, ma'am.
Has there been any development?
No, ma'am.
Any additional buildings?
No, ma'am.
Any additional businesses or anything for that matter?
No, ma'am.
Here at this time, the state would renew the state's motion to move in state's quadruple K into evidence.
Any objection?
Yes, same objection.
Objection, no, it's overruled.
Okay, and then with regards to state's quadruple, I'm sorry, that was state's quadruple K.
Excuse me one second. What's the exhibit gonna be? Okay, quadruple K, so
Quadruple K will be states 94.
94 and everything.
And with regards to state's quadruple J, I'm gonna show you that one now. And you previously looked at these?
Yes, ma'am.
In terms of the lighting conditions in state's quadruple J. I'm sorry, state's quadruple K. Travis, I think I mixed them up a little.
Excuse me one second, guys. Can you show the exhibit, see what I tried to spoke of, whatever's been done?
I didn't put the numbers on, so they can switch with the. Was that state's quadruple J? Actually, they just published the night 10 drive?
Yes.
Okay. Thank you.
So correct date, please.
So states quadruple
J.
J will be states 94.
Thank you.
So showing now
Excuse me, is that the flyby or the drive?
driver.
Drive.
So in looking at what has been marked now as state's quadruple K for identification, is the lighting conditions the same
No, ma'am.
in terms of being able to accurately show the path of travel as determined? Is this the most efficient way of doing it?
Objection leading.
Sustained.
In terms of doing this on the nighttime drive on that? Or there changed road conditions?
The reason we filmed this during the day was because of the lighting conditions makes it more visible. The recording studio is no longer there. When we did the actual nighttime drive, there was construction on 595 and 95, so we had to divert. We didn't start. We had to extend the recording a little bit. So
So in terms of the recording that is in right now is states 94 from the exit of Miramar Parkway and I-75 to Pembroke Road and US 27. Is that fairly accurately fixed?
yes, that's yeah.
So in terms of showing the actual road travel, how does the flyover show that better than trying to drive?
It's a more accurate depiction because it's at night. You can see it a lot easier. The construction is no longer on 95 and 595, so it clearly depicts the path was taken at night.
Was there construction on October 26th of 2018 on those areas?
Not to my knowledge.
Here at this time, the state would renew its motion to put states quadruple K in as states 95.
Objection on relevancy, predicate, foundation.
Thank you. Objections, no, it's overruled. It'll be admitted.
So states quadruple K will be states 95.
95. Perfect. Okay. So I would start with publishing states 95. So Detective Ray, if you could please point out what we are looking at here first. Oh, and the lights, please, Travis.
Right here is the, where the point studio used to be.
And so at the top of the screen, is there a compass which indicates the heading?
Yes, right there. And this is Flagler Street, which goes up to Sunrise Boulevard. And then this is Sunrise here. And you make a left, which then would head west on Sunrise Boulevard. Take Sunrise west to 95.
Detective Ray, when you did the drive of this, it took approximately how many minutes to get from the studio to Miramar Parkway?
Probably about 20 minutes, 25 minutes like that. This is the 95 ramp here.
And so which direction is the helicopter that you're in traveling now?
We are moving south now.
When you get to Broward Boulevard, at that exit, we indicate please.
We took 95 down to 595.
Understood, and just for purposes of keeping references to where it is, are you for Broward Boulevard and other locations? Was that Broward that was just passed?
I believe so, ma'am.
So where is the helicopter traveling now at this point?
We are turning west onto 595. That would be the turnpike entrance. Still on 595 heading west.
And just so it's clear, you can indicate which road is the pointer on the big screen, so we can see which road we're following.
We're still on.
Okay. And Detective Ray, I think the next thing I'm gonna ask you to indicate to the jury when the express lane toll booth is shown. So we watch the footage from already.
We're gonna be closer to 79.
running enough to go back to your Air Force days. What is an airspeed of 100 knots translate to?
I didn't fly to military man.
Okay.
If you look to the right, it has the miles per hour.
Thank you.
Passing hiatus coming up the flamingo. That's the Southwest 136. And that will be the
Southwest 136 right there, or I'm sorry.
well, it's 136 right here, and then there's the sun pass.
Okay.
And then we'll be turning south on I-75 heading south.
Just need to indicate which road on this would be that direction.
That's right.
Check right, the pausing on this one for me, when it gets to, I think, 16 minutes, we'll pause it and switch to the other view.
We just got shared the street. Pine Boulevard.
Second, Marie, what is the exit just before Miramar Parkway?
Pine Boulevard. Raising Miramar Parkway.
Okay, and then at 15:07, and we're stopping it at 15.
I'm sorry, can't hear you. What?
Sorry, I'm gonna let it continue on until 15:30. Now publishing states 94. Travis, I'm gonna ask the other light as well, please.
Is that exhibit 94 or 95?
94.
94.
So Detective Ready, if you guys explain where this video picks up.
We are right now on the off ramp to enter onto Miramar Parkway from I-75. We are now on Miramar Parkway, heading west, approaching Southwest 160th Avenue, which is also known as the Dykes Road.
And to the right of the screen, what direction is that cardinal direction?
To the right of the screen, that would be we're traveling west now, so to the right would be the north.
Okay. And if you could, when you get to the Pollo Tropical, if you could identify that.
We just, there's a Chili's just past there. Should be coming up to a Target. That is the entrance to Regional Park, which is on the right side. We're still heading west. I guess the Pollo Tropical right there. Gas station, we should be coming up to Southwest 172nd Avenue, which is the McDonald's.
And if you go north on Southwest 172nd Avenue, what is located at Southwest 172nd Avenue, Pembroke Road?
That would be the hospital, Memorial Hospital.
And if you indicate again when you get to 184th, which is the end of the walking, I believe you testified to by the officer Miramar.
Yes. This is 178, which is Silver Lakes, Southwest 178 Avenue. The next light you see, the green lights, is going to be Southwest 184th Avenue.
To get to the entrance of 40th Street for Sunset Lakes, the guard gate. Which way would you turn at 184th?
You make a left and you would head south on 184th.
You turn right on 184th.
You head north into Pembroke Pines.
On Miramar Parkway, does it connect through to US 27?
No. This is 184th right here. You turn right, which is heading north.
During the time of this video, are you operating the vehicle?
I am driving and Miss Carroll is recording in the passenger seat.
Are you observing posted speed limits?
Yes.
Are you purposely driving slower than the speed limit?
I'm driving exactly. I'm driving exactly at the speed limit. We're coming to Pembroke Road.
Does Pembroke Road connect through if you turn left there to US 27?
No. The red lights we're approaching is Hines Boulevard.
Does Pines Boulevard connect to US 27?
Yes, ma'am.
What is the next road? I'm going to rephrase. Is there another road in Broward County south of Pines Boulevard that connects to US 27?
No, ma'am. We now turn left, which is heading west on Hines Boulevard.
And when the Montessori Academy is on the left, because the road is indicated.
This would be the Montessori School.
Okay.
to US 27. We will make a left, head south. We're coming up to Pembroke Road.
Is there a traffic light at Pembroke Road?
No. We have a left-hand turn, which will be east on Pembroke Road. And then this is Pembroke Road.
Approximately what time of the morning is this that you're doing this video at right now?
We're here approximately at around 4 a.m.
How many times have you been out to this location before you did this drive?
Several times.
And what vehicle just passed you?
That is a waste management vehicle going out to the dump. Now we're turning around.
Is there a particular reason you chose that spot to turn around?
That was the approximate crime scene location.
As we turn here on 27, you're going to submit this to be a logical place to break?
Yes, ma'am.
All right, your own lights, please. Thank you. I made a joke soon after 5, so my colleagues will break through the tape. Remember the admission, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence. So you know, research, just leave no heads on your chair, see everybody back tomorrow at 9. Thank you, ladies and gentlemen.
All right, y'all, we are down. It looks like to the end of this case, to be honest. We will start back up on Thursday. Yeah, on Thursday, with day 13. So happy New Year, everybody. Thank you for rocking out with me today. I hope y'all have a good evening. Be safe, and I will see y'all later. Peace.
You're watching